Okay, boom. Sorry, I was juggling. I had my stream open somewhere and I couldn't tell where it was. It was echoing in my ear and I had to shut that down before I properly could boom. So, boom. Hey, folks. Ah, it's been a day. How are you, folks? Um, Hopefully the lighting isn't too bad here. It's not great. I'm still working on how to get this all. No, that's even worse. There we go. Now I look like a human being or an elf being. Uh, Trying to work on the lighting and all of that, and the things that work for recording and the things that work for live streaming seem to be different things, and I don't really understand why. So, yeah, the new camera I am still working on, and I don't know, the camera may not end up working out, but I'm going to keep the camera if only to do filming in other scenarios because I've got I've got other things where I can, where I want to film. So I got to get a tripod, I got to get all sorts of stuff. It's going to be a headache and a half. But um let's see. What else have we got today? We got a whole bunch of things on the go. And yeah, so some of them are going to be sensitive topics because one of the topics is a lawyer who has been accused of loving his dog too much. So, because we cover sort of shenanigans in the legal profession a fair bit, we're going to look at that. Am I still stuck in the mud? You bet. My car is still stuck in the mud. And yay! Yeah. All right. So I'm just wondering where we should begin. Should we begin with something? What should we start with? Let's start with the Twitter controversy. The Twitter is all a buzz and all a flutter over a particular thing that is going on. And this thing is a guy who filmed himself getting certified or getting picked up on a certification. Oh, I'm being told I should begin with meetup details and a goal. So, meetup details. If you haven't heard yet, I am going to be in Chicago on the 30th. The 30th at 6 o'clock p.m. until we get tired and go home or they kick us out. So that is at the Green Door Tavern. I would love to see you all there. So, 6 o'clock p.m., May 30th, Green Door Tavern. I will be there. I will be hanging out. I will, it should be pretty awesome. So yeah, looking forward to seeing some folks and meeting some people. I have done meetups in the past, and I can say I have really enjoyed every single one of them. I really have the best fans. I have the best, I got the best community, and it's really great. It's just so I'm psyched for that and looking forward to it. So for the goal, if we hit the goal, I'm going to let you guys choose my drink adventure. Because right now, the drink I have open is a Red Bull. Now, the Red Bull they've got some new summer flavor. It's a lime, and I really like it. But what is it? Femme Dandy San Francisco would be great. I should do that. But yeah, I've got several possible drinks sort of arranged here. And yeah, Can I do a brief live stream from the meetup? Maybe. I can't say for certain, but maybe. We'll figure all that out. How do you drink all that stuff and keep your heart in your chest? Well, I mean, if I croak, I croak. It's that's how that goes. All right. So let's start out, and hopefully we don't get taken down, but these videos are on TikTok, so hopefully they don't get me nuked. But if they do, we will have learned a valuable lesson about not being dumb on my end. So let's have a look here. I just got to add it. And this is the video that's gotten everyone on Twitter very annoyed. Very, very annoyed. Oh, and I got to close disclosure windows so that those don't accidentally pop up. All right. So, and here we go. Let's do that. Okay, so this guy has put this video up online, and lots of people have had commentary about it. Let me know if you can hear it properly, or if you can't hear it. And we'll watch this, and then we'll talk about it. So here's this guy.
Yeah. Okay. And this is Dr. Emery. He's a resident psychiatrist, senior resident. He's on a rotation with the CAR 87. We're part of a program that includes Vancouver Coastal Health and the Vancouver Police. Okay? Mm-hmm. And what we do is we go to people when there's different reasons that come up. Every case is a little different, and we go to people to see them where they are, especially if there's been issues with trying to find them and talk to them. So in your case, I think you were certified under the Mental Health Act just, I don't know how long ago, but like maybe 3 weeks ago or 4 weeks ago. Were you aware of that? Dr. Taylor saw you in a cafe. She didn't certify you. I think you filmed part of it. And then she spoke with your family, got some more information. And, you know, you're going to have to turn that off.
So just one sec.
Yeah.
What the officer just told me is that, you know, you and I can set up a meeting and we can chat then. So why don't we do that, okay?
Yeah.
I'm not turning the camera off. I have a legal right to keep the camera on. If you don't want to make the appointment now, we can do it at another time. But, you know, that's what the officer just asked that we do. So why don't we do that?
So I'm going to certify you under the Mental Health Act. We're going to bring you to a hospital, do testing on you. And you're going to talk to a psychiatrist in a controlled environment, because we don't believe that you're going to attend an appointment.
I won't attend. I've never been given a chance to attend an appointment.
So he's certified. Yeah.
I've never been given a chance to attend an appointment.
Okay.
What is going on? I was never given a psych eval or nothing. He just looked at me and said, "You're certified."
Yeah. Okay. So I don't know why, but it's up to the doctor. So if you.
But no, he didn't even give me an eval. He just looked at me and said, "I'm certified." Man.
I get that.
You know, please consider what you're doing, and please think about the fact that I'm more than happy to come in for an appointment. I'm happy to go through and do everything properly. Okay, I've been completely compliant with everything.
Yes, you've been really good with me, Nicholas. But listen, that's his call, and unfortunately, we can't go back.
He hasn't talked to me.
Checked out by a doctor.
You're interacting with me at a very.
Okay, so what's happening there is he's getting certified under the Mental Health Act, which means at that point he gets taken to the mental hospital for 48 hours. And during that time, they can evaluate. They can also impose treatment. If at the end of the 48 hours, and folks, I see that YouTube is not handling the goals. They are, you know, so Tide has got it. Tide's keeping track. So they can hold this guy for up to 48 hours. And you know, during that time, they do evaluation, they do all of that stuff. Now, if at the end of the 48 hours, they think there's still an issue, they can recertify under a different form, and the different form allows them to hold him for up to a month. Once that happens, he can apply for review, and that review happens fairly quickly. They get the review going within a week or two. At that review, he's able to present evidence. He's able to call witnesses. He's also able to, they will provide him with a free lawyer. And so he will have legal counsel. Now, a lot of people have watched this and they've been going, oh my God, this is crazy. This guy doesn't seem that bad. They're just, why are they grabbing this guy? And the thing is the reason why that Mental Health Act provision exists, why they have it, is because they actually, it's intended for use to protect people who are either a danger to themselves or a danger to others. And we don't know what the actual circumstances are for this guy. We don't know what it is that got them to certify him, other than what it appears is that he was at a cafe and he was acting oddly. And a psychiatrist observed him at the cafe and took notes and didn't certify him at the time, but did refer that for some further investigation. And what you can hear in that, this is actually in British Columbia. This is in Vancouver. And yes, in Canada, they have a legal right to challenge it while they're in the hospital. It's within 2 weeks. But what you also hear in this video is they did some investigation before they pulled this guy over.
Issues with trying to find them and talk to them. So in your case, I think you were certified under the Mental Health Act just, I don't know how long ago, but like maybe 3 weeks ago or 4 weeks ago. Were you aware of that? Dr. Taylor saw you in a cafe. She didn't certify you. I think you filmed part of it. And then she spoke with your family, got some more information, and you're going to have to turn that off.
Just one.
So you'll note the thing about they spoke to your family and they got some more information. They went and did corollary research. And I see somebody saying if somebody can be certified without an evaluation, that's complete bull. And the thing is that the purpose of the certification is to get the evaluation, because what happens at that point is the guy gets taken to the mental hospital and they will evaluate him. Now, I see this a fair bit with people who are, threaten to unalive themselves and, got to use the YouTube language, but they threaten to unalive themselves and they get picked up and they get taken in and they get evaluated and then they get released. So, but the thing is not always. And they were doing research on this guy. They were looking into him. And they probably had some concerns based on things like this. And this is from the guy's Instagram, I think it is. So let's have a look at this. You're allowed to talk to people. That's allowed. If it's not so urgent that they can sit on it for 2 weeks, it shouldn't be a certification. My bet is that they didn't sit on it. My bet is that they were trying to get this guy in and so forth. They just couldn't. But let's look at this.
I do not have enough evidence to make completely substantiated claims about Alex's ability to manipulate other people's thoughts and to use advanced mind control technologies on other people. I have various hypotheses and various theories that I do believe with quite a bit of secondary and tertiary evidence do align very well with this being real.
So he's identified a specific person as mind controlling him and others.
But I do not have enough primary evidence to, substantiate this 100%. What I can say is that the day after I chased Alex Rocket out of his apartment, a man who was very much involved in the Ukrainian mafia, who was most likely running most of their software, who was most likely running most of their cybercrime. After I ran him out of his apartment, the traffic in Toronto died.
Okay, I'm seeing some people saying it's too quiet to hear. Let me try turning this up, which I'll have to use a volume booster, but we're going to do that. We're going to go back to the beginning because people couldn't hear it. So, yeah.
I do not have enough evidence to make completely substantiated claims about Alex's ability to manipulate other people's thoughts and to use advanced mind control technologies on other people.
So again, he's identified a specific person as engaging in mind control. And this is a specific person in his life, a person he knows.
I have various hypotheses and various theories that I do believe with quite a bit of secondary and tertiary evidence do align very well with this being real. But I do not have enough primary evidence to, substantiate this 100%. What I can say is that the day after I chased Alex Rocket out of his apartment, a man.
So he's just identified that a specific person, he's chased them out of their own apartment. Okay.
Who was very much involved in the Ukrainian mafia, who was most likely running most of their software, who was most likely running most of their cybercrime. After I ran him out of his apartment, the traffic in Toronto died and then continued to get worse and has not recovered since. And in my best estimation and in my best opinion, what I would say is that a massive change in the behavior of a population of that size is a symptom of a larger underlying issue. And this symptom seems to be spreading to multiple cities. It seems to be spreading across the West, from my understanding. And again, there is a possibility that he is tampering with the traffic cameras that I'm looking at for across the country. So I cannot say with 100% certainty. But I do believe this to be a grave issue. I do believe he is a national security threat. I do believe he is a terrorist. And I do believe that if he is not stopped, many people may get hurt, and many people may have their autonomy taken away.
Okay, so what do we see? He has identified a specific person who is the focus of his concerns. That is a real person. It's not an imaginary person. He has indicated that he has chased that person out of their apartment, and he's indicated that he thinks that person is engaging in mass mind control and that they must be stopped or else bad things will happen. Which, I mean, I am not a psychiatrist. I have an undergraduate degree in psychology. And to me, this sounds like paranoid ideation, paranoid delusions, and paranoid schizophrenics. He seems to be the right age for that to hit. Paranoid schizophrenics are often lucid. They're often, they speak in an ordinary fashion. They just have these, particular things. So that's my suspicion, but I don't know for certain. This is something, and the thing is that this is the kind of place where somebody who does know for certain, somebody with the appropriate, credentials, it'd be good if they had a talk with this guy, right? And I'm seeing paranoid schizophrenia isn't a diagnosis in the current DSM. Fair enough. But yeah. He also has a manifesto online, and he so what I've heard is that he's been putting this under people's like going around and putting this under people's windshield wipers. And it says, warning, this is not solicitation. If you find this document unattended, do not remove it from the property where it was placed unless you are the owner of said property or party to said property. Removing this document constitutes an indictable offense carrying a penalty of up to 10 years in prison, obstruction of justice. this guy is wrong on the law there. He is, but he's talking about this document contains evidence of crimes the government is committing against each individual, treason, etc. And he's got proof of work for unified theory of gravity and nuclear fusion solved. Holographic gravity has been verified via nuclear fusion. Yeah. He ties in the gun confiscation. I mean, I'm sympathetic to your concerns there, but yeah. So anyway, there are some really, really good reasons to think that this guy might actually be a concern. Certainly when I look at this, I go, huh. And specifically, I'd be concerned about the dude that he is saying, this guy must be stopped in a tremoring, like, I'm like, oh, this is not good. This is potentially real bad, because there is the real possibility that, so yeah, the thing is that let's imagine, so a lot of people are freaked out about this, and I get it. We don't want the idea of like they can pick us up, randomly off the street. And it's not random in this case. They clearly researched this guy. However, I just want to note that if you, Amy, I'm told that he is a real guy. He indicates that, so he provides in his story, he specifies that he hired a software developer in Toronto, and that is the guy he's sort of fixated on here, this Mr. Rocket, who he accuses of being affiliated with Ukrainian and Bishnoi organized crime groups. Now, there are organized crime groups along different ethnicities, but Ukrainian and Bishnoi are not working together, right? That's not actually like a thing. And yeah, so this guy has also been repeatedly calling the police and, trying to get them to act against this one specific dude. So if the police got all of this and they just were like, well, nothing we can do, right? Nothing that we can do on this one. Well, if something bad happened, they'd definitely be saying, why did nobody do anything here? And so the law does allow for, for this, but there are restrictions. As noted, if he's ordered held for longer than the 48-hour assessment, then he will get a hearing and he will be, he will be brought in and given free counsel. I have been the lawyer on some of these proceedings where where people have been held, and sometimes these are people who've been held because I represented, without giving too many details, I represented a guy who was in his 8th year and of being involuntarily held in a psych facility. And when asked what he would do if released, he indicated that he was going to hurt a few specific people. And it's like, well, we are not a whole lot we can do here. So what'll probably happen is the guy will get assessed. If he's only mentally ill and he's not a danger to anybody and he doesn't want to get treatment, they'll release him. Because at that point, if that's all it is, he's got a right to be mentally ill, if that's where he wants to be. However, if he is mentally ill and he is a danger to people, including himself, then he can possibly be held for longer in order to, and they'll try to get him on medication. They'll try to get him on whatever, but there's people for whom medication doesn't work. And there's people who just refuse to take their medication. They just, they don't do it. So, yeah. I mean, the thing is that this guy, I think, needs some help, right? So, I mean, I don't know. I can't say for certain because I don't have all the details here. But I do have enough details here to go, this isn't completely bizarre, right? This isn't completely like, this isn't some situation where the cops are just like going off, half cocked or whatever. There seems to be an actual basis for this. I can't say whether they are right to be holding him or wrong to be holding him in law based on what we have. But we, we got questions, and ultimately that'll get determined. Yeah, and some people are wondering about, like, is this legal or wherever. This is in Vancouver, BC. So this is under the BC, the BC Mental Health Act. And, yeah, that's, that's that. The other thing that can happen if he's discharged, they can, in certain circumstances, they can either discharge him, in which case he's just like, free to go, off you go, you're under no rules, like whatever. That's what generally happens if the person turns out to be just like, okay, this guy's okay. However, if you've got somebody who's a danger, but that danger is mitigated when they're on their meds, they can release people and place them on what's called extended leave, which means that they do still have rules. They've got to potentially, like, talk to the mental health team every once in a while. They might be like given medications that they got to take. So, yeah, I mean, this is a difficult case, but I can say that I don't think that what they're doing is necessarily, that doesn't mean it is necessarily not, but I don't think that this is one of these cases where we can just say this is obviously an abuse, because it may or may not be. And at this point, I cannot say for certain, 100%. But yeah, covering this one because there's a lot of people on Twitter who are like super, super upset on this one, and we gotta sort of. I'm just asking people to kind of like dial back the outrage right now. There's always time to have outrage later. Now, I also am noticing that I missed a super chat that was sent in well before the start of the stream. And so we're going to hit that now. So I can't pull that one up yet. Or I can't pull that one up because it was, whatever, or it was before the start of the stream. But it was from Aqua, who says, long overdue. Thanks for all you do, sir. It was a $50 super chat, so I really wanted to make sure that, I properly recognized it and properly recognized them. So thank you so much, Aqua. It's very generous and really appreciated. All right. So let's talk about some other stuff going on, some other things. And I think the first one we're going to talk about is kind of the opposite of the first one. This one is going to be the story of Jennifer Lynn Combs. Now, what happens to Ms. Combs? Well, Ms. Combs is a resident of Trinidad, Texas. And Trinidad, Texas has some issues with its water supply. And she had some concerns about the water supply. She had some concerns, and yeah. Kimchi, Tide is keeping track of it. So the goal isn't tracking properly, but Tide is on it, and Tide is awesome. So, yeah. So she raised those concerns and she said, hey, I am concerned about whether this water is, healthful, whether this water is safe, whether this water is, and she got arrested and charged. She got charged with the issue of knowingly initiating a false emergency report. And what that's for is for somebody who calls in a fake fire or something like that, right? It's intended to capture the people who say who BS those kinds of things. If you call and say that there's a kidnapping or something else when there wasn't, then that's what this penalty is for. These things exist in just about everywhere because you get people who do things like call in reports of fires. These statutes can also be used against swatters or people who put in, hoax bomb calls, whatever, right? So they arrest her and they charge her, and the charges get thrown out because of course they do. These are just stupid ass charges. But she's not done. She's hired a lawyer who I'm hoping might be able to join us next week. We're going to talk about the case this week. You guys can get real familiar. And then next week, I'm hoping we can bring in the lawyer and have a discussion. So it's not firmed up. This is a hopefully at this point, but let's have a look at this case. So here we go. So Jennifer Lynn Combs is suing the chief of police of Trinidad, an officer in Trinidad, and Marie Bannister, city councilwoman, city of Trinidad. All right, so we're going to skip over the table of contents, but we're going to skip over the table of authorities. We're going to look at introduction. So this is a civil rights action brought pursuant to law and more law by Jennifer Lynn Combs, a working journalist and resident of Navarro County, Texas, against Trinidad Police Chief Charles W. Gregory, Trinidad Police Officer Cameron Beckham, Trinidad City Councilwoman Marie Bannister, and the city of Trinidad, Texas itself as an entity for systemic violations of rights secured by the First, Fourth, and 14th Amendments to the United States Constitution. This case arises from the weaponization of state criminal law to silence a journalist who dared to inform her community about serious and credible public safety concerns regarding the municipal water supply, concerns subsequently validated by the city of Trinidad's own issuance of a boil water notice. Rather than address the water quality crisis, defendants manufactured criminal charges against Mrs. Combs under a statute that, on its plain face, does not apply to her conduct. The charges against Mrs. Combs are not the product of legitimate law enforcement. They are the product of political retaliation, coordinated by a police chief who openly declared on a public governmental social media platform that reporting credible public safety information constitutes a felony, carried out by an investigator who admitted under oath that he operates in deliberate ignorance of First Amendment law, and instigated by a city councilwoman who harbors documented personal animosity towards Mrs. Combs and whose own family's ties to the city's water infrastructure give her a powerful motive to suppress exactly the kind of reporting Mrs. Combs engaged in. Oh, that's powerful shit right there. This is the lawyer coming out swinging, and I am here for it. I love it. And so, yeah. Now we have hit the goal, which means I have to do a poll. Start a poll. All right. If it'll let me. Okay. So the poll is, what should Runkle drink next? First up, red wine and Coke. Second up is clamato, and some spices. I kind of spiced this up, and beer. That'll be the second choice, is clamato and beer. I see somebody saying water. We don't do that here. The third choice is lemon drop martini. All right. Those are our choices. We're going to start the poll here. All right. We'll let that run for a couple of minutes. Just, let that go. While that runs, we will have this carry on here. The City of Trinidad bears direct institutional responsibility for these violations. Through policy, custom, and the deliberate failures of its senior policymakers, the city has established an entrenched pattern of retaliating against those who expose governmental misconduct, financial irregularities, and failures in public services. That pattern is reflected in the prosecution of Mrs. Combs, the removal of a city administrator for exposing financial irregularities, the constructive termination effort against a municipal judge who refused to participate in unconstitutional prosecutions. Wait, what? What? That I have questions. I have some serious questions. What is it? And the separate arrest of a citizen for holding a sign outside the Trinidad City Police, City Hall and Police Department HQ, reading "Fuck bad cops." Speech that is unambiguously protected by the First Amendment. I love this one because he doesn't even hold up a sign that says "fuck cops," because that would also be protected by the First Amendment and his absolute right to express that opinion. But he specifically just says "fuck bad cops," not all cops, just bad cops. And so, what is it? Why was Malort not on the poll? Because I don't have any Malort. I cannot drink Malort. I do not have. But, I mean, this guy just says "fuck bad cops." And it seems to me that if you're going to get upset by this, you're kind of telling on yourself, right? Because it's like, "fuck bad cops." And this cop turns around and is like, "You talking about me?" It's like, why would you think that, sir? Who said you? You said you. There's an old proverb that says, when you throw a stone into a pack of dogs, the one that yelps is the one that got hit. And the basic meaning of that is like, if somebody makes a general statement and you get mad and take it personally, why are you taking it personally? Why? All right. So, plaintiff seeks compensatory and punitive damages, declaratory and injunctive relief, and attorney's fees and costs pursuant to law. So, parties. We're going to skip the parties because they already basically identified who they are. Factual allegations. Jennifer Combs and her journalism. Jennifer Lynn Combs is a working journalist well known throughout Navarro County and surrounding communities for her persistent and principled reporting on matters of public concern. Her work consistently addresses issues of clear and compelling importance to the citizens of the region. Now, I don't know who she reports with, but I suspect that she's like reporting on Facebook or Twitter or YouTube or whatever. And the thing is that the other side might say, oh, she's not a legitimate reporter if she's only reporting on like Facebook, etc. And it's like, well, no, that is legitimate reporting. And quite frankly, it is what the First Amendment was there to protect. All right, so let's look at the poll. I just finished my Red Bull, And the poll is not even close. The poll has the lemon drop martini in a can as number one. So that is what we're opening here. Slancha. All right. So, carrying on here. For a substantial period prior to the events described herein, Mrs. Combs has been a vocal and persistent critic of high-ranking officials within the city of Trinidad, including defendants Gregory and Bannister. Her reporting has scrutinized their conduct, questioned their decisions, and held them publicly accountable on matters ranging from governance and financial management to public safety and the delivery of essential municipal services. I mean, I would have been like, do not target this person if they were doing that. Oh, is my camera? Okay, good. Camera's not not doing too much. All right. So Pants says the last time I had a lemon drop was at CrimeCon and Runkle was in the room. You know what I like better than a lemon drop, but it's hard to find a properly done one. I found a bar that did them right and I got smashed because I ended up having, I think I had 9. I think I had 9 of them. And it's a gimlet is actually kind of hard to find places that do right. Because a gimlet is lime juice and gin and some other things and, you know, whatever else. But most places that do a gimlet do it with like squeeze bottle lime. And squeeze bottle lime is nowhere near the right thing. To do a gimlet right, you need to do it with fresh limes. Like you need to cut a lime and, you know, all of that stuff. And most places don't do that because it's a pain in the butt. They got to keep fresh limes. They got to cut and prep the limes when it's doing it. But the difference between the juiced limes versus the, versus bottle lime is huge. And yeah, so they're good. I saw somebody say paper planes. I also like a paper plane a lot. So yeah. All right. So I got to start another goal. We're going to start the goal up here and see, places in Chicago will use fresh lime. All right. Well, we might we might have a couple. All right. What is a paper plane drink? It is Aperol, Amaro Nonino, bourbon, and lemon juice in equal proportions. And it's pretty what do you call it? It's the way I describe it is that the first few taste like a kind of much smoother lemon candy. And then, so like the first 3 taste like a lemon candy. And then the 4th tastes like a lemon candy with a slight floor aftertaste. Because those things will absolutely, yeah. So somebody was asking me to spell it. So there we go. Somebody says Naked and Famous. I don't know what's in one of those. All right. Somebody says, quick question. If not for the financial crimes conviction, would Murdaugh be out of prison right now? I doubt it. I suspect that if Murdaugh, the only thing was the retrial, that they wouldn't have him out on bail, right? They'd keep him in. So, yeah. I started a new goal, and the new goal is for me to give a closing speech. Now, this closing speech is, how do I put this? This closing speech is one that they absolutely cannot actually give. This is like my dream of what I would give as a closing speech if I could. And the reason why you can't actually give this one, yes, it's the same one as the fundraiser. The reason why you can't actually give this one is because it violates like 19 different rules on what you can do in your close. But it's fun, and I will give you the backstory and the reason for that close. But I do want to put the note on it that it is a fantasy closing, because you could never do that close in real life. Like, you would get absolutely like toasted if you tried to give this close. So yeah, close, not clothes. Okay, carrying on here with what we got. So the city of Trinidad's water crisis. Y'all ready to lose your minds? Because when you hear about what their water crisis is, y'all are going to lose your minds. The city of Trinidad has been experiencing significant, ongoing, and well-documented problems with its municipal water supply. These problems present a serious and unresolved public health emergency. Defendant Marie Bannister's son, Jerry Bannister, is a member of the Trinidad Economic Development Board. In statements he made on record, Mr. Bannister admitted that the city of Trinidad's water supply contains asbestos, a severe and well-recognized public health hazard for which there is no safe level of human consumption. Asbestos. Now, I just want to talk a little bit about asbestos, because asbestos is actually highly relevant to the legal profession. If you are in an area where lawyers can advertise and you turn on the TV, like every time I go to Vegas and I turn on the TV and watch the TV, you get lawyer ads, and the lawyer ads come in and they say, "Do you have mesothelioma? If so, you should call," and then it's some lawyer saying, call me if you've got mesothelioma. And the reason why is that if you find a lawyer who owns like a giant yacht, that lawyer is probably an asbestos lawyer, just playing the odds. Asbestos lawyers earn huge money. And the reason why is that there is a government fund that pays out for asbestos claims. And asbestos is still out there. It's still floating out there. And, so people are still getting affected by asbestos. And there are huge claims. And the other thing is that asbestos litigation is actually kind of really depressing. So, I mean, I know there's somebody who's hearing this and they're like, I'm a law student and I think I'm going to go into asbestos litigation. Y'all, asbestos litigation is great for the money, but it's not great for the life. And the reason why it's not great for the life is because asbestos is, by the time somebody comes to you for asbestos litigation, they have mesothelioma, right? And mesothelioma, the usual outcome of being diagnosed with mesothelioma, is death. And so basically every person you talk to, if you are an asbestos lawyer, is somebody who is dying. And a lot of them will die while the litigation is ongoing. So a lot of those things, we will have situations where, like, as the lawyer, you're rushing to get the evidence out because your client isn't going to make it to the end of the litigation. and knows they're not going to make it to the end of the litigation. They are pursuing this because they're like, I'm mad that I'm dying and dying slowly and painfully and, all of this. And I want money for my kids. I want money for my family. I want money for, yeah. So, I mean, it's super depressing. If you want to do litigation where your clients are dying, asbestos litigation is number one. Number two is criminal defense. And the reason why that is because there's just fentanyl everywhere. And yeah. All right. So, asbestos in the drinking water. They note a severe and well-recognized public health hazard for which there is no safe level of human consumption. Now, I did see some people noting that, that like asbestos is only dangerous if you breathe it. That is not true. Asbestos is dangerous anywhere it can impact a mucous membrane, which, is your lungs. But the thing is the reason why people get get mesothelioma and, in their lungs and not anywhere else is that people don't normally drink asbestos. It was never a food additive. Asbestos was largely used for insulation and so forth. And the purpose of the insulation and, so it gets into the air and it gets into, but if you introduced it to any other, mucous membrane, it'll impact you there. So if you did decide to drink asbestos, it's not good for your insides. If for some reason you decided to boof asbestos, like if you are the owner of the world's only asbestos dildo, you would get serious medical conditions with wherever you put that thing. So, pro tip, do not buy an asbestos dildo. There's a phrase that, there's a phrase you didn't expect to hear tonight. All right. So, yeah, the asbestos in the water is a thing, is a problem. So, Defendant Bannister is fully and personally aware of the water quality crisis affecting the city of Trinidad, including the presence of asbestos in the water supply by virtue of her son's position, his on-the-record statements, and her own role as city councilwoman responsible for overseeing the delivery of municipal services. Notwithstanding this knowledge, Defendant Bannister worked to suppress public reporting about the water quality crisis rather than address it. How are they doing it, keeping that water quality crisis under wraps? I feel like it's getting more attention now, just a wee bit. So plaintiffs protected reporting and the Facebook post. At a time relevant to this complaint, Mrs. Combs received credible reports from members of the community regarding the safety of the city of Trinidad's drinking water, including accounts that at least one individual had been hospitalized as a result of consuming the water. Acting in her capacity as a journalist and in service of the public's fundamental right to know about matters of vital community concern, Mrs. Combs published a post on Facebook informing the public of these reports. The post conveyed information she had received directly from community members concerning the quality of the municipal water supply and the alleged hospitalizations resulting from its consumption. So when you think about, why does the First Amendment exist? Right? Why is that a thing? Well, the First Amendment exists so that you can criticize the government. And when you think about, why would you want to criticize the government? Things like, hey, government, maybe there shouldn't be asbestos in our drinking water is one of those things, right? It is a good reason why you might criticize the government. So, I mean, I don't think that the founding fathers specifically considered asbestos, but, this would have been the kind of thing they would have said, like, you know, if you'd explained it to them as like the government is leaving poison in the water and they don't want us to know about it, then, like, you know, George Washington and, you know, all, you know, Thomas Paine and whatever would have been like, yeah, I'm writing a fucking pamphlet about this shit, right? But nowadays we don't write pamphlets. We go on Facebook and we talk about it. Facebook is the pamphlet of the modern era. So, all right, the Facebook post addressed a matter of the highest possible public concern, the safety of the community's drinking water. Such speech occupies the highest rung of the hierarchy of First Amendment values and is entitled to the fullest constitutional protection. When they talk about the rung of constitutional or First Amendment values, what they mean is that when they do First Amendment analysis, like freedom of speech, and this is true in the US where it's the First Amendment, and in Canada where we have freedom of expression. It's similar but different, and yeah. So when we talk about that, there are like different levels of, you know, of how much something is protected. And so at the top, the tippy top level is criticism of the government. And then below that, you have things like expressing personal feelings and opinions and values, but still way up there, right? And you can go down several rungs into things like commercial speech, right? Commercial speech is considered less important than speech about the government. So, in fact, shouting to a cop, fuck the police, and giving them the birds has a higher level of constitutional importance and protection than does somebody saying something like, you know, hi, this is my new product. You should totally buy it because it is awesome and contains a minimum of asbestos, right? So, these kinds of things is, you know, there's kind of a different, you know, and you can look at like what's at the bottom, right? At the bottom of, you know, expression are things like obscenity, like posting a picture of your junk online is kind of at the bottom of like expression. It's stuff that is like, and, you know, these things. Now, I saw somebody talking about Facebook's like terms of service. Facebook is in the government. The First Amendment applies to the government, not to any of that other stuff. So, when they say highest rung, that's what they mean. All right, Mrs. Combs did not fabricate an emergency. She did not summon emergency responders. She did not trigger evacuations. She reported accurately and in good faith what community members had told her about the safety of their water, performing the most basic and constitutionally valued function of a journalist, informing the public about matters of genuine public safety concern. That is kind of what we think that journalists should be doing, right? Just a wee bit, right? So, Texas Penal Code, the state under which Mrs. Combs was charged, is narrowly directed at persons who knowingly initiate a false emergency report that causes an actual emergency response. For example, falsely reporting a fire, explosion, or similar incident. It has no application whatsoever to the act of a journalist sharing community safety information with the public through social media. No good faith application of the statute reaches Mrs. Combs' conduct. So, the city's boil water notice corroborates plaintiff's reporting. Shortly after Mrs. Combs published her Facebook post about the safety of the city's water supply, the city of Trinidad issued an official boil water notice for the municipal system. A boil water notice is issued by governmental authority when the water supply is or may be unsafe for human consumption. The city's issuance of that notice directly and powerfully corroborates Mrs. Combs' reporting and is wholly inconsistent with the assertion that her public statements were false or constituted a fabricated emergency. I mean, to the extent it's an emergency, Trinidad reported that this was a problem. They note, additionally, multiple citizens posted replies to the Trinidad Police Department and City of Trinidad City Hall's own social media posts stating that they had personally been hospitalized or affected as a result of consuming the city's water. These citizen statements, published on the city's official law enforcement social media page, further confirm the accuracy and good faith of Mrs. Combs' reporting. Now, I just want to talk about something else, which is asbestos was used as insulation. And the reason why it was used as insulation is A, it turns into this lovely powdery stuff that gets into your lungs, but also is great as being like fluffy insulation. But one of the big problems they had with insulation is that in the era where asbestos was super popular, the alternatives were things like cellulose. And the cellulose, nowadays, cellulose insulation is like soaked in fire retardants. Back in the day, cellulose was not very fire retardant. It was, in fact, very fire prone. You know, if you had that old school cellulose that wasn't soaked in like fire retardants, if you held a match to it, it went up like basically shredded newspaper, which is basically, so the asbestos got as popular as it was and was, considered as awesome as it was at the time, because now you didn't have the houses that just burned up like a candle. You had houses that actually stopped the fires. Like the asbestos would keep the fire from spreading through those spaces. So, what this tells you, or the important thing to take away from this, is that asbestos is one of the few compounds that we know of that neither burns nor melts. It just doesn't do that. So boiling it isn't going to get rid of much of anything at all. Because boiling only gets to 100 degrees Celsius, because of course that is the boiling point of water. I don't know what it is in freedom units, but so the it's not able to get rid of asbestos. It's just not. So like, we're going to boil this and 212 freedom degrees. Okay. The asbestos is not going to be affected by a boil water thing. This is a good point. Boiling asbestos water only increases the asbestos amount in the water. I looked it up. Yes, because the water turns to steam and evaporates, and the asbestos doesn't, so you're actually concentrating the asbestos if you boil the water. So, the retaliatory prosecution. Defendant Gregory, acting in his capacity as chief of police and senior policymaker for the Trinidad Police Department, directed defendant Beckham to investigate and pursue criminal charges against Mrs. Combs arising from her Facebook post about the city's water supply. Just stop here and think about this one. The chief of police heard about a Facebook post and was like, I am personally, as the chief of police, going to do something about this and direct an officer to go stop this person. And I'm like, you what now? You are going to, like, why would the chief of police take a personal interest in a Facebook post unless it was something like a person who's going to, like, take a run at the president or something, right? So, yeah. The charge brought against Mrs. Combs under the Penal Code is legally frivolous on its face. The statute does not apply to Mrs. Combs' conduct. By the way, these charges were thrown out in like record time. Like it was just so fast. The statute does not apply to Mrs. Combs' conduct. Any officer exercising good faith professional judgment. Okay, now we're talking about unicorns and leprechauns. An officer exercising good faith professional judgment? Sure, put it next to the dragon and the Wendigo. Like, come on. Are we serious? And even minimal familiarity with First Amendment principles. All right, we're going to put it with Ogopogo. Would have recognized that no basis for prosecution existed and that initiating such a prosecution would violate clearly established constitutional law. The decision to charge Mrs. Combs was not a product of legitimate law enforcement judgment. It was an act of deliberate political retaliation driven by Mrs. Combs' history of critical journalism directed at defendants Gregory and Bannister and coordinated through a conspiracy among all individual defendants. I feel kind of bad about this, but I have to.
Conspiracy.
I mean, the thing is that usually when you go conspiracy, usually it's like, well, it's not a conspiracy. This one kind of feels like conspiracy, but I still got to play the thing because, Duckman, and yeah. So, what do you call it? A person of ordinary firmness would unquestionably be deterred from engaging in constitutionally protected journalistic activity, including reporting on municipal water safety, by the prospect of being criminally charged with a state jail felony for doing so. So, yeah. Defendant Beckham's admitted ignorance of First Amendment law. On May 13th, 2026, the day after the press release announcing the charges against Mrs. Combs, Defendant Beckham, the lead investigator in the criminal matter, made admissions that he does not consider and is not aware of current case law governing the statutes he enforces. Now, I mean, most people don't consider current case law, but yeah. Specifically, Sergeant Robert McCumsey admitted that the department has not received First Amendment training in several years and that First Amendment principles played no role in his investigative decision-making. Maybe that should change. Like, maybe they should get some basic, basic clues here. These admissions are constitutionally dispositive. The decision to investigate and charge a journalist for publishing a Facebook post about a matter of undeniable public concern was made by an officer who, by his own admission, was operating in a state of deliberate ignorance of the constitutional constraints on his authority. Yeah. Pedro de Great asks a really interesting question. What if a person isn't ordinarily firm? Because they talk about a person of ordinary firmness. And the answer is, it depends, which I know is a super lawyery answer, but it depends. So to a certain extent, there is an element of take your victim as you find them. And what that means is that if you walk up to some random person on the street and you punch them in the face randomly, and it turns out that they have a, what's called a thin skull, which means that they, by their nature, are especially vulnerable to being punched in the face, and they die. Well, you're at fault for causing the death, right? But there's other provisions that talk about like a person of like a reasonable person standard. So for instance, like criminal harassment, right? If you are charged with criminal harassment in Canada, the standard is basically an ordinary person, right? Would an ordinary person feel that this was an issue? Or would they just be like, whatever? And being especially fragile doesn't actually, change things. Did I hear about the bricks and minifigs situation? I did not. I don't know what you're speaking about, Ludwig. I'm not going to read the rest of your username there, but let me know. I'm curious. All right. So, Beckham's acknowledged lack of First Amendment training is directly and causally attributable to the deliberate policies and customs of the defendant's City of Trinidad and defendant Gregory as senior policymakers. The failure to provide constitutionally adequate training on the First Amendment, particularly for officers investigating and enforcing statutes with direct implications for protected speech, constitutes deliberate indifference to the known and obvious risk that untrained officers will violate citizens' constitutional rights. Y'all, read that first citation. Just read it to yourselves before I get to it. City of Canton versus Harris. I don't think it's that Canton, but it might be that Canton. And I'm like, how are we in Canton? How did Canton follow us to this thing? Dragon, the judge threw out the case before I actually could get to covering that case, but I do have a short about that case because there is a funny moment about it. So, yeah. All right. Defendant Gregory's warrant shopping and the circumvention of municipal court. Rather than present the warrant application in this matter, to the City of Trinidad's own municipal judge, an officer who's been openly critical of defendant Gregory's unconstitutional law enforcement practices, defendant Gregory deliberately and intentionally sought out a justice of the peace to sign the arrest warrant against Mrs. Combs. If you are a police officer and you find yourself needing to I can't take this in front of this judge because they'll reject it, then you shouldn't be taking it to any judge. Ever. I see people saying it's Canton, Ohio. I feel like Canton is the same Canton everywhere. I feel like it's the universal Canton theory, that they're all and I haven't tested this. This is just a hunch. So, yeah. All right. The Justice of the Peace selected by defendant Gregory had pre-existing potential conflicts and documented public disagreements with Mrs. Combs prior to the warrant application. Defendant Gregory was aware of these conflicts and selected this magistrate because of, not despite them. And I'm like, oh my God. Because if I'm a justice of the peace and I hate Bob, I'm like, fuck you, Bob, you suck. And then a warrant application comes across my desk and it's for Bob. And I'm like, you know what I'm doing with that warrant application? I am handing it back to the officer and saying, this has got to go to someone else, literally anyone else, because I can't touch this. I know Bob. Bob is a sack of shit. Bob can go fuck himself, but I can't sign the warrant application against Bob because I think Bob is a sack of shit who can go fuck himself. That is how that works. So I feel like the JP also has some issues in this particular, thing. Defendant Gregory's deliberate selection of a judicially compromised magistrate, one with documented personal and political opposition to the target of the warrant, rather than presenting the application to the city's own municipal judge, reflects Gregory's awareness that the warrant application was constitutionally deficient and his calculated effort to ensure issuance of the warrant that would not survive neutral judicial scrutiny, i.e., he knew his warrant was shit, and therefore and so he looked for a biased JP. I actually really like this idea. Can we please have Bob knows what he did and justice for Bob merch? Then we can all vote with our wallets. Honk Banana, no. I love the idea. But I'm going to put a caveat on it. And the caveat is that I cannot set up that merch until after I get back from Chicago. And the reason why is because Bob in my hypotheticals is a hypothetical Bob and not a specific Bob. But if I post that shit up while I'm in Chicago, everyone is going to assume I'm talking about the specific Bob of Bob Motta. And Bob Motta is an awesome dude. I like Bob. And in fact, I'm going to be staying with Bob. So we're not doing that. So, but after I get back and like a week later, I could try to make the shirts because, and Tide, can you please remind me that I have to, that I have to do that? Because, yeah, that it's got to be a thing. Bob Motta would be 100% cool with that. I suspect so. Yes. Yeah. And Bob is, Bob's a good guy. I like, Bob Motta. Bob, hypothetical Bob is the terrible person. All right. The circumvention of the municipal judge was not accidental. Defendants Bannister and Gregory separately engaged in an ongoing effort to constructively terminate the municipal judge's employment, at least in part because the judge has refused to participate in defendant Gregory's unconstitutional law enforcement actions. Can I just say how much this is an insane statement? Insane. Like, they tried to... constructive termination here would mean basically they want to prevent this judge from being able to do their job without actually getting the judge fired. But this coordinated pressure on judicial officers is itself evidence of the conspiracy described herein. I would love to see the discovery on this case. The discovery on this case would be like, yeah, I just, yeah. All right. Defendant Gregory filed a complaint against Bivens towards this goal and then later retracted the complaint to avoid discovery of his involvement. Defendant Gregory's official social media admission of retaliatory motive. If you have not been like, wait, what? You should be like, wait, what? The Trinidad Police Department maintains an official Facebook page. Defendant Gregory was responsible for and administered that page in his official capacity as chief of police at all times relevant to this complaint. Because of course he does. Following Mrs. Combs' arrest, the Trinidad Police Department's official Facebook page published a post authored or authorized by defendant Gregory stating that Mrs. Combs was arrested for stating that our water was causing people to be hospitalized due to bacteria in our water, which was false and caused a panic and alarm to the public. This post constitutes an official government admission that the basis for Mrs. Combs' arrest was her public statements about the safety of the community's water supply, i.e., her constitutionally protected speech. The same post further stated that communicating such information of public concern about the city's water supply is a state jail felony. They're saying it's a felony to tell people that the water is unsafe. You gotta be kidding me, right? This statement, made by the senior policymaker of the Trinidad Police Department on the government's official governmental platform, constitutes an official governmental threat against any citizen, journalist, or whistleblower who would report on or merely repeat community concerns about the city's water supply. It is a textbook example of the viewpoint-based governmental suppression of protected speech that the First Amendment was designed to prevent. No evidence of panic and alarm beyond the ordinary and constitutionally protected public discussion of a genuine matter of community concern has ever surfaced in connection with Mrs. Combs' Facebook post. So when you think about what this law is intended to deal or to do, to handle is it's intended to address issues of, like you cause a false police response, right? Or you cause people to panic and stampede out of some place, right? In some ways, this is like the yelling fire in a crowded theater statute, but, not entirely. And I've just opened a can of worms that is like, I don't want to go there. But, right, you don't want to have people evacuated or whatever, like all of the bad things that, that cause all these issues. You don't want that. And so that's what this is intended to deal with. But I just want to talk about like a water supply problem. Like, what kind of panic are you going to get if the water is no good? Like, you can't stampede to not drink water. You can't, like, run away from the contaminated water. You just decide not to put it in your mouth hole or any other hole. So, this really isn't intended for this kind of issue, right? To the contrary, the community response was precisely what the First Amendment is designed to facilitate: informed public discussion of a public health emergency. Multiple citizens confirmed, in replies to the TPD's own posts, that they had been hospitalized as a result of consuming the city's water. Even if the post had resulted in panic and alarm in the community, it was based on the protected speech of a journalist communicating a matter of public concern. So, yeah. Defendant Bannister's role in the conspiracy. And I'm sorry, we have to do the thing.
Conspiracy.
Not gonna lie, I kind of love the thing. It is probably my favorite Duckman episode, and Duckman was a good show. Although, do not show it to your kids. It's animated. It's not for kids. It used to play at like 1 a.m. because, yeah. All right. So, defendant Mary Bannister is a city councilwoman who has long documented or maintained a documented personal and political animus towards Mrs. Combs, arriving from plaintiff's journalism critical of city officials, including defendant Bannister herself. So there's this thing that happens. D-Starfire, we can count it. The goal is not counting anything today. So the goal is sucking, but I think Tide is managing the counting. So yeah. When you do a journalism, and when your journalism is critical of somebody, they will often decide that they hate you. They will often feel that they are the wronged party, and they will often want to, in some way, get revenge. This is just a thing that happens. And it happens, in all sorts of scenarios. But politicians especially feel that they need to, to deal with this kind of thing. But again, it's not just politicians. It tends to be people who are in positions of, positions of trust, positions of authority, or positions of status. You have never seen somebody get so pissed off about being criticized until you see, like, a doctor, a lawyer, a police officer, a priest. Yeah. And sometimes you encounter people who are just like spun glass. They might be some sort of narcissist. They might be some sort of, egotistical sack of crap. And they will especially take all of this, really personally. And you know what? People like that have a tendency to gravitate to those positions of, like, authority or assumed respect. So, Yeah. So defendant Bannister is intimately and personally aware of the water crisis affecting Trinidad. Her son, Jerry Bannister, a member of the Trinidad Economic Development Board, that should be board, but it's BORA, and president of the Planning and Zoning Commission, has admitted on the record that the city's water supply contains asbestos and other lead contaminants. So, asbestos isn't lead. Asbestos is asbestos is asbestos. It doesn't contain any lead. But lead is also not good. Like, lead should not be in your drinking water. Lead, that is not a thing that ought to happen. So, yeah. And the other thing about lead also doesn't get cleared by a boil water advisory. Boil water works on like bacteria and potentially viruses that are inactivated within that range of, 100 degrees Celsius, right? And like, that's just how that works. But if you boil the water, the lead doesn't go away. Lead can't die, right? Like, that's not how that works. So, despite, or more precisely, because of this knowledge, defendant Bannister conspired with defendant Gregory to manufacture criminal charges against Mrs. Combs in order to suppress plaintiffs' reporting about the water quality crisis and to retaliate against her for years of journalism critical of city officials. I'm kind of feeling the need to be critical of these city officials at this stage, right? So, yeah. Somebody asked, does asbestos die? No. Asbestos does not die. So I was going to do a little Cthulhu poem there, but yeah. So defendant Bannister's participation in the conspiracy to silence Mrs. Combs is consistent with and constitutes part of a broader documented pattern of retaliatory conduct in which defendant Bannister has engaged against persons who expose governmental misconduct in the city of Trinidad. The city of Trinidad's pattern and practice of retaliation against critics and whistleblowers. The retaliatory prosecution of Mrs. Combs is not an isolated event. It is the most recent and most constitutionally egregious manifestation of an entrenched, deliberate, and long-standing governmental practice of retaliating against citizens, public employees, elected officials, and members of the press who expose governmental misconduct and failures within the city of Trinidad. Oh man, the discovery on this is gonna be sweet. I mean, the lawyer will deny it when he comes on the stream, if he comes on the stream. But this is the kind of thing where you're just like, you know what? I'm not even going to finish the sentence. It's awful. The amount I would want to read the discovery in this case is just off the charts. So, yeah. So defendant Bannister led the effort to remove the city of Trinidad's previous city administrator from office. That administrator was removed as a direct consequence of her disclosure of financial irregularities within the city, precisely the type of disclosure that the First Amendment, sound governance, and the public interest demand be protected, not punished. Defendant Bannister is currently engaged in a deliberate effort to constructively terminate the employment of City of Trinidad's municipal judge in concert with Leah Melton, who is not yet named as a defendant in this case. I love the word yet in that sentence. I love that. Speaking of people named Robert, how is Law and Lumber? He's doing okay, but he's still dealing with some things. So, yeah. Speaking of which, I got to book a ticket I got to do that. So, all right. This effort is directly connected to the municipal judge's refusal to participate in Defendant Gregory's unconstitutional law enforcement actions and, upon information and belief, her refusal to sign constitutionally deficient warrant applications. Constructive termination of a judicial officer for acting with fidelity to the law is itself an unconstitutional act that forms part of the pattern and practice alleged herein. Taken together, the removal of the city administrator for exposing financial irregularities, the constructive termination of the municipal judge for refusing to participate in unconstitutional prosecutions, and the criminal prosecution of a journalist for reporting on water safety constitute a coherent, deliberate, and entrenched policy of governmental retaliation against those who challenge or expose the misconduct of city officials. So I just want to note here, I am, I'm very concerned by all of this. Now, all of this at this point is allegations and shade, right? This is issue, like they can allege all sorts of things in, at this stage, and they haven't proven anything. But if what they're saying is true, and again, that's an if what they're saying is true, this is like them coming after all the corruption, right? All of the corruption. And yeah, I see this comment. Yeah, those aren't things you can boil out of water, and there's some microorganisms whose spores you can't kill by boiling the water either. Luckily, those ones doesn't tend to be the ones pathogenic to us. However, there is one big exception to that rule. And this is a big exception that is worth noting because it is a public health concern. You know what you can't boil out? Botulism. Botulism cannot be boiled out. Botulism has to, and this is why if you are doing if you're canning stuff, you must use a pressure canner for certain things, because if you pressure can stuff or if you can in the old-fashioned canning style where you're not using a pressure canner thing, stuff that is subject to getting botulism, you can die. Like, botulism can straight up kill you. And one of the things that is incredibly dangerous, and when I say incredibly dangerous, it actually is responsible for some ridiculously high number of botulism poisonings, notwithstanding the fact that not a lot of people are doing this. Garlic in oil. So preparations where garlic cloves or garlic chunks are soaked in oil is a perfect incubation period or incubation setup for botulism. And specifically, garlic often has botulism in it. So the oil, garlic does, or botulism does not like oxygen. And so if you take olive oil or something like that and you soak garlic in it, you have a real possibility to die. So, just a thought. It's something like half of botulism poisonings are connected to that, which is like a ridiculous amount. So, all right. Additional evidence of Defendant Gregory's contempt for constitutional rights. The prosecution of Mrs. Combs is not an isolated reflection of Defendant Gregory's disregard for the constitutional rights of persons under his law enforcement authority. In a separate and recent incident, Defendant Gregory oversaw the arrest of a man for the act of uttering profanity and holding a sign reading "Fuck bad cops." This expression, however offensive it may be to law enforcement officers, is unambiguously protected by the First Amendment. And the thing is that this should not be offensive to law enforcement officers, because if you're a good cop, you should also hate bad cops, right? That straight up. What do you mean I cook everything with garlic? What are you talking about? You're just saying how dangerous Tylenol is, and now you're on about how all garlic is made of botulism. What? No, garlic will tend to have a little tiny bit of botulism, not enough to bother you. The problem is that if you soak it in oil and you create this environment where there's no air and you leave it there for months, right? It sits there for like 3 years. Well, now the garlic, that garlic, 3-year-old garlic in your cupboard, you would throw out. But that 3-year-old garlic that's in the oil will eventually, or can eventually, develop enough botulism to, that the botulinum toxins that it produces will kill you. So that is the danger. Now, you're not going to get in trouble just eating ordinary garlic. You're not going to get in trouble, like in situations where botulism is exposed to air, it's generally, it's not going to get to a point where it can kill you. Botulism kills people from canning accidents because all of the air is taken out. That's when it becomes, potentially dangerous. But I mean, I love garlic, and if a Mysterica clause, if you are buying it, then it will have been pasteurized or otherwise treated to make sure that you're fine. We're talking about homemade treatments. If you're buying it from the store or whatever, you're okay. Don't buy it from farmers markets. Don't yeah. So, I mean, the thing is, if a doctor told me that I could not have garlic, he's like, Runkle, you can't keep eating garlic. I'd be like, doctor, how long do I have to live? Because that shit ain't happening. Pickled garlic should be fine so long as it's pickled in an acid solution and not oil. You should be fine. So, all right. In a separate and recent incident, defendant Greg, we talked about that. The Supreme Court has held that offensive speech, including profanity, is constitutionally protected. Criticism of law enforcement is not only protected, but lies at the very core of the First Amendment. The arrest of a citizen for holding such a sign is a paradigmatic act of unconstitutional viewpoint-based suppression of protected political speech. So, this incident, considered alongside the prosecution of Ms. Combs, demonstrates that defendant Gregory operates with a settled and deliberate practice of suppressing speech critical of his department and of governmental authority. That practice has gone uncorrected by the City of Trinidad and its governing body, rendering a municipal custom for which the city bears direct Monell liability. So this is partially, the language here is to fit it within certain legal tests. That is, a thing. This is why when I can, I'm super annoying about sterilization and keeping everything clean and only canning high acid foods in the hot water canning method, pressure for anything else. I want a pressure canner. I don't have a pressure canner, and I want one, but I don't want to buy just any rando pressure canner, because there's lots of pressure canners on the market, and I don't want to buy just any rando pressure canner. There is a specific brand of pressure canner that I want, and it ain't cheap. It is not cheap. It's the All-American. The All-American pressure canner is, it has no rubber gaskets. It just, sits on a stove, and that's how it works. And they are mad expensive. They are not cheap at all. And yeah. There are other ones I might consider that are electric pressure canners. And the problem is that those are also super expensive. So all of the pressure canners are really, really expensive. And I just cannot. It's not that I can't afford it, because I could, right? I could do it. But my particular variety of like cheapness does not brook paying like $500 for a canner, and that's $500 US. So yeah, I see them at thrift shops all the time. I have never seen an All-American at a thrift shop here. So yeah. And I mean, I look on like Facebook Marketplace every once in a while. What is it? Runkle, I have an All-American. How can I contact you? I'm in Vegas, but you can have it. Oh, Lights, Camera, Cactus. That would be incredibly generous. I am on Twitter. You can send me a DM there, or my email address is on my YouTube page. I swear I wasn't trying to beg one, but I was just complaining. But yeah, that might be amazing. I got my All-American canner from a Facebook free ad. I've seen 2 of them since. I've never seen one. I monitor that. So yeah, I've got various things that where I search. So all right. The defendant Gregory's status as both the senior policymaker for the Trinidad Police Department and a former city administrator means that his deliberate unconstitutional practices are directly attributable to the city. So this is kind of a similar thing to what do you call it? To like vicarious liability. Wasn't trying to beg one, but he'll gratefully accept one. And you were just sharing canning dreams. You're not wrong. The what do you call it? Like the next time I experiment with some hot sauce, I'd like to be able to can some. So now I'm pulling up Facebook Marketplace while I stream, just like looking at canners too. So preservation of notwithstanding clause argument on qualified immunity. Now this is kind of interesting because this is a thing of how do I put this? A preemptive argument, because normally when you have one of these arguments, the how do I put this? Normally you'd file your argument and they would raise a defense of qualified immunity. And then you would say, well, no, that's not true. Here they're doing it in advance. Runkle, where is your email? If you go to the About section on my YouTube page, you can find it there. You can also, it's runkleofthebailey@gmail.com is my email address. So you can track it down there. All right. So to the extent any defendant raises qualified immunity as a defense in this action, plaintiff expressly preserves and incorporates herein, as if set forth at length, the argument that the doctrine of qualified immunity lacks statutory authority and is constitutionally and historically unsupportable as applies to suits under this specific set of law. And I'm like, I like you. Because what this tells me is that they're contemplating, or at least keeping on their, keeping on the back burner as an available strategy, the approach of we're going to attack qualified immunity as a concept. Like, not just like, you guys are, whether or not these people are, specifically subject to it, but like the concept of it applying to any human being anywhere. And I'm like, ooh, I'm I'm here for that. Yeah, it might surprise some folks, but All American is a bigger brand in the US, in America, than it is in Canada. just as a general thing. All right. So the original Civil Rights Act, the predecessor of the modern thing, provided that any person who violated civil rights under color of law, notwithstanding any such law, ordinance, regulation, custom, or usage of the state to the contrary, shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress. This express notwithstanding clause affirmatively displaced any contrary state or common law rule, including common law immunity defenses from the reach of the statute. He's not just saying, hey, I could fight this. He's like, I'm going to lay out some arguments here. I'm going to lay out some arguments for qualified immunity being complete shit. And I will just say, if this lawyer successfully manages to nuke qualified immunity in any case, or if any lawyer ever beats qualified immunity, oh man, like that person will be a hero to so many humans. Like that will just be amazing. That is like, oh yeah, that is where we want to be. And I am just like living for that possibility. And yeah, it's I just like, I don't even know how to say how amazing that would be, because qualified immunity is basically the get out of jail free card for a lot of bad cops. And you know, I could go on a whole stream about qualified immunity, but yeah, it is bad. So this critical notwithstanding language was omitted from the statute during the 1874 codification of federal law, not through any substantive congressional decision to alter the statute's scope, but solely for the purpose of concision and drafting economy, without congressional authority to effect a substantive change. The codifiers explicitly disclaimed any intent to alter statutory meaning. Am I going to GameCon? Where is GameCon? I don't know. I don't have any plans to go to GameCon, so yeah. The Supreme Court's recognition of qualified immunity in Pearson versus Ray rested on the premise that Congress had not explicitly abrogated common law official immunity when it enacted this law. That premise is historically false. The original 1871 Act's notwithstanding clause was an explicit abrogation of exactly such immunity. In Edmonton next month, I will have to figure out where that is, and I will have to consider it. So the foundation of the qualified immunity doctrine is therefore undermined by the historical record. And I am like, just like, you know, put that on my pancakes right there, because I love that to bits, and love it to bits. Honk Banana started my day in the ER, false alarm, and now finishing the day with Runkle and bourbon. All in all, net positive day. Honk Banana, no, you are giving me some concern. Yeah. All right. I see something that I missed from Cookie Mon Steve. Yeah, we'll figure it out. Plaintiff acknowledges that the Fifth Circuit remains bound by Supreme Court precedent recognizing qualified immunity, and plaintiff preserves this argument for purposes of en banc review and certiorari, and alternatively argues that even under existing qualified immunity doctrine, no defendant is entitled to immunity because the constitutional rights at issue were clearly established at the time of the violations alleged herein. So there's this principle of clearly established for qualified immunity. And what this is intended to do, what this is supposed to cover, is this situation where the officers are acting in good faith, but the law is not determined, right? That the law is not decided. And, and so the officers doing their best to follow the law, but they run afoul of it. But that's not how it ends up working. What it ends up doing in practice is that it ends up being a real problem, in that the way it tends to get interpreted is that so long as there is not a case that specifically says the exact thing that the officer did is against, is unconstitutional, then they're like, well, it isn't clearly established because, they have this case that says that the officer violated somebody's constitutional rights when he kicked him in the left testicle. And, that was an issue. So that was decided back in 2024, but now it's 2026 and he kicked somebody in the right testicle. And that's a completely different fact scenario. And how was he supposed to know that kicking somebody in the right testicle is going to be the same rules as kicking somebody in the left testicle? So the officer gets to skate. And if you're like, man, this is some bullshit, this specific example has not happened. But it comes real close, right? It comes real close. And yeah. So they say no reasonable officer could have believed that the actions taken prosecuting a journalist for reporting on public water safety, arresting a citizen for holding a protest sign, or threatening communities with felony prosecution for discussing government services were constitutionally permissible. So, cause of action, retaliatory prosecution, i.e., they went after her for exercising her rights, and that's, yeah. Count 2, First Amendment, viewpoint discrimination, chilling effect, and prior restraint, i.e., preventing the speech because of the content of the speech. Conspiracy to violate constitutional rights. They work together to violate the rights. And so, conspiracy. Fourth Amendment, false arrest and unlawful seizure. And so that's, there's an issue. The false arrest is pretty easily made out by how fast these things get, punted. Municipal liability under Monell. We're not going to cover Monell, but yeah. So issues of direct policy through the actions of a final policymaker, failure to train, widespread custom and practice of retaliatory suppression, ratification, declaratory relief. We want a declaration that my client's rights were violated. Injunctive relief. We want an order saying you cannot do it again. Damages. We want money. Money. So prayer for relief. We want judgment. We want money. We want asshole tax, punitive damages. If you've seen, Fight Club, where she's like, I'm not giving this money back, consider it asshole tax. Like, that's punitive damages. Enter a declaratory judgment. So we want a declaration that you violated our rights. Issue an injunction preventing them from doing it again. And award attorney's fees because we ain't cheap. And pre- and post-judgment interest. And so they want a jury trial. That is from GFA Law, CJ Grisham, who I'm hoping to lure onto the stream. So, yeah, that is some shit. Now, I am going to drop a link in the chat. And I am going to pin the link if I can catch it, because catching the link is sometimes hard. Here we go. And pin message. There we go. So I have pinned a message there. That is for a Give Send Go. And the Give Send Go is for the legal fees of Ms. Combs. So she's trying to raise money to cover that. I have posted, or I've tagged that. If you want to support that, then that's the link. So, yeah. All right. Let's cover super chats and see if we hit the link. So, yeah, all right. Super chats, where'd they go? Here they went. All right. So Aqua says, long overdue. Thanks for all you do, sir. Thank you so much. Apocalypse DOA. So my tumor removal was success. Gut pain galore. Cheers on the removal. Tumors are one of those things we want to get rid of, and I'm glad it's gone. Hopefully the gut pain goes as well soon. Glamasu says, don't forget to set a goal. I am terrible at that. Vez from Quebec. Sorry I missed you last week. Here now. The Green Door Tavern is 14 and a half hours drive from here. I know you can do it. It's a long drive for me. I got to move my passport to my bag too. So Patricia says, cheers. Cheers. What is it? Random Unbreaded Commenter says, Jim McIntyre right now. I don't do mind control. Go away. A girl named Joey. Thank you so much. Harbinger of imminent death. If you want to challenge your detention in one of these facilities, what kind of lawyer do you look for? What are your rights regarding talking to a lawyer? Usually, a lot of that is done by criminal defense lawyers. Sometimes there's lawyers who specialize in it, but mostly it's criminal defense lawyers who do some of that. Beautiful messy ball, except MK Ultra was real, and they made people who believed in it to be crazy insane too. So there's that. I don't think that's what we're looking at here, but so Brentwood Chic, late tax, lurking tonight. Good to see you. Random Unbreaded Commenter. The tunes, they are very loony today. Some shrink here. Yeah. Skol, Prost, cheers. Thank you, Beamer. Honk Banana No, thank you for the 10 gifted memberships. Much appreciated. Brentwood Chic. Okay, Runkle, time to admit you're really a Nordic alien. Nordic aliens are supposed to be like 7-8 feet tall, and I'm 5'10" on a good day. Like, on a good day. And when I say on a good day, I'm not trying to bullshit. What I mean by that is that when my back is bad, I shrink. So on a day when my back is really good and I'm feeling great, I top out at 5'10". And on a day when I'm really bad, I hunch over. So, okay, Ruckle. Yeah. Are chemicals in the water turning the frogs gay? No. They're just giving them cancer. Glamasus, in memory of all who sacrificed their future so we can have ours. Absolutely. Including the people who sacrificed parts of their future or elements of that. Steve says, for the drink adventure, thank you so much. Oh, you mean your back? Yes, my back is a thing. Music to my soul. I vote for trying to go live from the meetup if you can to alleviate my FOMO. Also, your dream closing on the fundraiser stream was great. We will probably be doing that tonight. Also, I will try to go live from the meetup, but I can't make promises. Pamela Wissenbach, for the drinks. For the drinks. Cheers. Brenda's 6461. Always enjoy your shows. Thank you so much. Cosmooks. I can't drink Malort I don't have. Runkle, that sounds like a skill issue. I don't like Malort is not a common thing here. Like to get Malort, I would have to find a specialty liquor store. Like it's not something that is just going to be commonly carried. Now I'm doing a search at one of the liquor stores that is not too far from me, but carries some interesting or weird stuff. So I just did a search there, and it came up with nothing. So, let's see. Spirits miscellaneous. Whiskey, wine. I'm trying to see if they have Malort. I doubt they do. Malort is a very unusual or unusual product here. Recovery Cat, thanks for being you. And Flag from Alberta too. I am here in Alberta, so I got to do an Alberta meet one of these days. Steve A42 says, wow, a third year snuck in when I wasn't looking, and I'm glad it has. Katie Hewling says, color me intrigued, sir. Good. Honk Banana No says, a Runkle Fever Dream rant sounds absolutely bananas, and as a rule, I support all things bananas, obviously. Light Queen says, hello from Vancouver Island, Canada. Thank you for all you do. I haven't been to Vancouver Island in a while, and I want to. 24 months. Put hot sauce or bitter in everything. Light Queens, thank you so much. JMR, ignorance of the law is not an excuse unless you are a cop. I actually made this argument successfully at the Supreme Court of Canada. And so the argument was the, the Supreme, I was at the Supreme Court and I was like, and they're like, well, these poor officers didn't know. And I said, justices, when we're dealing with a mentally ill person with a meth addiction and who hasn't slept in, 48 hours, we hold them to the standard of perfect knowledge of the law. Perfect. However, when instead we're dealing with a police officer who has access to, legal advice and gets legal education and so forth, we hold them to the standard of, well, you tried. And that feels unfair, right? It feels like the officer with all the education should be held to the standard of getting it correct. And that that the guy who is just, some dude with a meth addiction should only be held to the standard of, well, you tried, if we're going to do it that way. Right. So I'm just like, it feels wrong to me. It feels like, we've got that just, completely backward. And I mean, I'm never going to get the court to agree because they, how do I put this? The court likes cops better than it likes meth addicts. That's the easiest way to put it. But, yeah. D Starfire, thank you so much for the gifted memberships. Much appreciated. Donnie Not Wahlberg, thank you for the heart emoji and heart emoji back. Frisvold, thank you for the super sticker. Music to my soul. Runkle, you could make the merch now, but then gift Bob Mata a Justice for Bob shirt. This way everyone wins. So I committed over the next 30 days with Rumble. Rumble asked me to commit to doing, a 20 shorts in 30 days. They also want me to gain 100 subscribers. So if you guys could go over to Rumble and hit the subscribe button, that would be appreciated. But it means that this month is going to be a bit busy. I got to hammer out a whole bunch of shorts. So we gotta do that, but yeah, we'll see. Fiona W., thank you for 10 gifted memberships. Much appreciated. Ben Frail, one word no one has mentioned, fluoride. I don't know that fluoride's in the same category, but I don't know. Carago, love your analysis and stories, Runkle. I look forward to Monday Law Fun Days. I'm typically replay crew, but happy to be watching live tonight. Cheers. Cheers. Good to have you. Cookie Mon Steve, hey, Ian, are you going to GameCon this year? I am. I'm going to see about that. I'm going to try. Musings of apathy. Qualified immunity should shift liability to the agency instead of killing the case. If someone follows their training, they should not be personally punished. I feel like they should still know the Constitution, though. So I feel like that is a thing. So, Secret Labs customer support. Honk Banana No needs to respect the inherent dangers of sitting wrong. I see Naomi saying, damn it, I hate shorts and how they're shoving them at us. Yeah, just sometimes when you've got an opportunity, you got to sort of go for it, right? So, yeah. The civil rights lawyer covers Manel claims fairly often. It's a fairly poor replacement for actually holding the individual poorly behaved officer, I think, liable. Yeah, you're not wrong. Hello, it's Britt. Hello, Britt. Beth loves things. Love your uncle. Need a visit a use fund. So, yeah, I don't know. I've thought about doing that, like setting up like just a long running GoFundMe or something that just is like Runkle visit Australia. And then, say like at this point, I will go visit Australia and set up a meetup in whatever city, like, I don't know, Perth, Brisbane. I'm not sure where the place to do it would be, but, and then just like leave it open. And if it ever hits to like, enough things, I'd be like, okay, I'll go. But I don't know. And I'd need to do like 50 of them for like different countries. So, I don't know. I see somebody saying Melbourne. So yeah, I'd have to figure all that out. Yeah, I just have to see about that. Yeah, somebody's saying there's a big difference between Perth and Brisbane. I mean, you're not wrong. You've got Australia, which has like highways that run across it that people die on. Like literally die on, because there's like warnings of like, you do not have enough gasoline. You do not have enough, you don't have enough gasoline. You don't have enough water. And, turn back unless you know what you're doing. Is Rumble free? Yes, it's just a subscribe button. So I got to ask, I'm not in the position to give, but I'll support by subscribing, liking, commenting, sharing, watching. Yeah, all of those things are free. So, yeah. This is just a bit of like diversifying my pool, because like YouTube is demonetizing a bunch of channels, and you never know, right? So if something gets demonetized, I don't want to be in a position where I just suddenly lose everything. So yeah, that would be that'd be a thing. So sort of breaking out and branching out and having multiple income streams is a good idea. Hi, Palm Mom. Thanks for the live. I'll finish on replay. Thank you. M448.5. I should use this. Well, thank you so much. And Lonely Lark, shall I bring Bob shirts for Matas on Saturday? I mean, Lonely Lark, you'd be more than welcome to. So, yeah. All right. What should we cover next? Guys, should we cover something? What is it? Hoping to come Saturday. It's 3 hours away. Should we cover something a little bit spicy? Maybe a little bit? Okay. We're gonna cover something spicy, and we're gonna try to do it in the thing. Oh yes, I'm forgetting the Rumble rants. We gotta read the Rumble rants. Drex's unused item says, "Oh, you want to take me away and put me in a padded box against my will? Are you familiar with the sound of a bolt carrier being sent forward? Apparently not. Here, let me help you familiarize you with it. Yeah, it's not a good strategy. Drex's unused item says, I know for a fact if someone called my mother to ask whatever BS questions, she'd be calling me, informing me she told them to go sodomize themselves with a cactus, and asking if I have enough ammo. And same Drex's unused item says, to be fair, he wasn't entirely wrong. Something did happen and someone did have their autonomy taken away. Self-fulfilling prophecy. Yeah, you're not wrong. So, all right. So, I see somebody saying not the dogs. Okay, we'll skip the dogs for now. We'll come back to it. We will instead do a little segment I always love. I just got to find it here. Where is that segment? This is the one. Okay. And now we run the thing, the banner. We usually have tourists who go straight for the picturesque water and then nearly drown because they don't know anything about the ocean. I mean, I know the ocean can kill me, and I also know that Australia's ocean is especially bad because the Australian ocean is full of things what can kills you. And yeah. All right, so we're going to cover a little case that nobody's ever heard of. This is the case of Twig et al. Versus BSN Sports. And I don't know what this case is about. I don't. And I don't really care. But I do care about some of the fun. And here's the fun. So they note all three parties currently part of this case undertook the risk and chose to proceed to trial. Following a 6-day jury trial, plaintiffs filed an omnibus motion seeking various forms of post-trial relief. And defendants have since filed various answers and briefs in opposition to that motion. And as a result, the omnibus motion is now ripe for disposition. While it appears that both parties have a great deal more to say on the issues raised in the omnibus motion and various other indiscretions of counsel, now you should be perking up. At some point, everybody, soon or late, sits down to a banquet of consequences. That time has arrived for the parties in this case. That quote apparently is from Robert Louis Stevenson. And the quote of banquet of consequences, chef's kiss. Like, just chef's kiss to banquet of consequences. Right? It is I love that so much. But let's go to the part that we're going to talk about here, which is robot lawyering. Now, I mean, at this day and age, if you are using ChatGPT to pull citations, you're a moron. There are some legitimate uses of like ChatGPT, etc., but you got to be real fucking careful. You got to think of like ChatGPT as like an ostensibly helpful assistant that every once in a while just gets the urge to destroy you. So yeah. Mr. Mattiacci's use of artificial intelligence. In defendants' briefing on this omnibus motion, they have raised a troubling issue with Mr. Mattiacci's citations in his brief in support of his motion. They point out that he cited cases that are fabricated, cited cases that are real but wholly unrelated to the issues they are proffered to support, and cited to quotations that do not appear in the text of those opinions. After a lengthy review of the cases cited, the court believes that not only are defendants correct in their assertions that many of the citations in his brief are false or completely irrelevant, but there are additional citations to cases throughout this brief that do not remotely relate to the assertions advanced by Mr. Mattiacci. Mr. Mattiacci responded to defendant's notation of these errors with vitriol, claiming that these fictitious citations were clerical errors, scrivener's errors, or minor technical discrepancies. He tacitly admitted that the errors were due to the use of artificial intelligence, but his statements in this reply fall far short of taking responsibility for these gross misstatements. If you are a lawyer, if you fuck up, the best thing to do is to own that fuck up as soon as you can. Leonard French, who's also got a YouTube channel, he says this as eat crow while it is young and tender, or otherwise you will have to eat the crow when it is old and tough. And the basic thing is, if it's a fuck up, you can very much, the sooner you take responsibility and the more fully you take responsibility, the less likely it is that that is going to absolutely fuck your life up. Right? I had a moment at one point where I had a filing that was late. And so I was going into court and I'm asking for, basically, I'm coming in hat in hand to say, I fucked up. I need some more time. And so I went into the court and I was like, Your Honor, this deadline, I missed it. I'm really I'm asking for an extension. Please assist. And then the judge was like, Mr. Runkle, how did this error happen? And I said, well, Your Honor, I asked my assistant to diarize the date, and my assistant diarized it for a week from the date. And so when it came up in my calendar, I thought that was the deadline. I was wrong. And the judge says, Mr. Runkle, are you saying this is your assistant's fault? And I said, no, Your Honor, I'm not. I am saying that this is how this happened, but the fault is with me. I should have checked. I should have monitored my assistant better. I should have provided better training. The fault is my own. There is no displacing fault. And the judge said, Mr. Runkle, I am going to skip the lecture I was going to give because it appears you already understand the lesson. Crown, is it any problem if I give him the extra week? And the Crown said, no, we can live with that. And the judge said, okay, thank you, Mr. Runkle. Make sure you don't miss this deadline because you've already had an extension. That was easy peasy, right? And the reason why it was easy peasy is A, not in the habit of making screw ups, and B, I owned it and I took responsibility for it. I said, this is my fault. This is my thing. And, but when you bullshit, that's when you end up really screwed. And that's what's, the court's finding here. So instead, he claimed that these errors were identified and mostly corrected and stated that they were a byproduct of a shifting landscape in the legal professional, not a lack of candor. He's like, case law moves so fast, right? Despite claiming that they were corrected, 8 days after the filing of his reply brief, Mr. Mattiacci filed a motion to amend his brief in support to include a sheet that attempted to correct further errors. This errata sheet fixed one or two of the errors, but certainly not all that appear in his filing. Yeah. What is it? Many of the attempted modifications add the "see generally" signal to cases that are irrelevant to the matter cited. Adding a signal to a fictitious or irrelevant case does not make the material magically support Mr. Mariachi's arguments. Oh, the court does not like him. The court's got some opinions. The proliferation and availability of artificial intelligence tools presents a challenge to the legal profession. Lawyers have duties both to their clients and to the courts to present accurate facts and citations to legal authority. Here's the other thing about this. If you as a lawyer are using ChatGPT, well, you know who else can use ChatGPT? Anybody. And if anybody can do it, like any moron can ask ChatGPT to generate them a brief, then you as the lawyer are adding no value. Zero value. And the thing is that people hire a lawyer specifically because we know ChatGPT fucks up. And we want to, we want to have that, we want to have that there. What does candor mean when it is used by the courts? I often hear judges talking about a lack of candor with the court when lawyers do sketchy stuff. Candor with the court is openness and honesty. And sometimes candor to the court requires you to proactively identify problems. Like not just deal with it as it comes up, but to deal with it in advance and to raise it even when the court doesn't yet know. So as an example of like candor to the courts issue, you have a preliminary inquiry, and for some reason your client decides to testify at the preliminary inquiry. And your client says, I was never at, the liquor store. And then you, in your discovery, determine that your client was at the liquor store and that your client is lying about this. Like maybe you're just like, you tell your client like, hey, can you document where you were? Do you have any? And they're like, oh, I was totally at the liquor store. I just lied to the court. At that point, you have an obligation to go back to the court and be like, I have to correct the record. You may have, and it's even worse in terms of correcting the record if it was you that submitted it. Now, you can run into ethical issues and ethical obligations because, sometimes you're in an ethical obligation in terms of like, you have an obligation to your client. So as an example of a thing that occurred, this is like an actual thing that occurred here. And I had this client, he's in jail, and he's like, all right, I'm in custody and I want bail. So we go to address his bail, and his girlfriend shows up and she hands me a treatment letter. It confirms that he's got a bed available in an inpatient treatment facility. And I'm like, that's awesome. But you got arrested 2 days ago, and there's no way you got an inpatient bed in 2 fucking days. And also, I know the letterhead of this particular agency, and this ain't it. This letterhead that you've handed me is, in fact, you taking their logo off of their webpage and just sticking it into a Word document. This is an obvious and plain forgery. So I go back to my client who's in cells in the back, and I'm like, hey, hi. And he's like, hey, did my girlfriend give you a letter? I'm like, she sure did. And the client's like, yeah, so I got this treatment bed. And I'm like, you have got to be shitting me. I hold up the letter and I'm like, are you shitting me? And he's like, no, what's the problem? I'm like, it's an obvious forgery, you dumb shit. Like, it is an obvious fucking forgery. And he's like, oh, you caught that, did you? And I'm like, yeah. And he's like, so what now? I'm like, so here's the thing. I can't take any of the things you told me now and go into the court and repeat them as if they were accurate, because I know you're a lying sack of shit. So, you fired. You done. I will not be your lawyer anymore. And he's like, oh man, what does that mean? I'm like, well, it means you should put this over and get another lawyer. And he's like, but I want bail. I'm like, yeah. I know you do, but I would not recommend going for bail today. So I come out and I go up to the court, and this file has been kicking around. This file was like ages old. So the judge wants it to move. And the judge calls the matter, and I get up and I'm like, Your Honor, I need to be removed as counsel of record. A conflict has arisen. And the judge says, Mr. Runkle, what is the conflict? And I say, Your Honor, that is privileged, but a conflict has arisen. I cannot tell you what the conflict is. And the judge was like, Mr. Runkle. And I'm like, Your Honor, here's the case. There is a case that says, in a situation like this, I am supposed to tell you that I have a conflict, and that's all. And she's like, okay, Mr. Runkle, I understand. Have a seat. I want to talk to you later. And I said, okay. She said, you are not to leave my courtroom, Mr. Runkle. And I said, okay, because, angry judge pissed. So I'm sitting there, and they have the accused there, and the judge says, Mr. Blankety Blank, Mr. Bob, what do you want to do in your matter today? And he says, Your Honor, I would like to speak to bail. The judge says, okay, Crown, are you ready to speak to bail? The Crown says, yes, we are. So the bail hearing begins, and they go into how much this dude is a bad dude. And we ended the poll with red wine and Coke winning. So there we are. And the Crown talks about how much this dude is a bad dude and how much he, and all of this. And, okay, so they make their case. They go over to the defense, and he is speaking on his own now because, he just, I just got off the file. And, he talks about, Your Honor, I have a real problem. I've got addiction issues. But the thing is, I don't want to be just released because I'm, a bad dude. I'm going into treatment, and I have I have documents to confirm that I'm going into treatment. And, here's the thing. And they pass up the documents. And the judge looks at it, looks right at me, makes a little face, and then looks over at the accused and says, so have you reviewed this document? And he says, yes, I have, Your Honor. And she says, and you're telling me you have a, a treatment bed? And he says, yes, I do, Your Honor. And she says, bail is denied. This document is a clear forgery. And the fact that this individual was willing to forge a document and present it to this court indicates that he is not in a position to be released on these charges, particularly given the, the record alleged by the Crown and the, the circumstances alleged on this offense. Sir, you are denied bail. I'm putting your matter over for 2 weeks. I suggest you get new counsel. And he gets carted out. And the judge turns back and says, Mr. Runkle, I think I understand what happened here today. I no longer need to speak with you. Have a good day. And so the judge is like, I get it. I see what happened here. And it was just like, bye. This same judge at some point, she did not like my principal. And I mean, she had good reason to not like my principal. The reason why she didn't like my principal is that he had serious ethics problems that eventually got his ass disbarred. So, like, you know, her dislike for him, way legit. So, yeah, somebody's asking, is that a gaming steering wheel? No, it's a pop filter. But she was kind of, yes, the lawyer I articled under. So at one point, we finished up a day in court. It was a thing. And she was like, Mr. Runkle, could you stay a moment? And I was like, okay, Your Honor. And the judge is like, Madam Clerk, the recording is off, correct? And the clerk is like, yeah. She's like, all right. Mr. Runkle, you might have noticed that I have been strict with you over the last year. And I was like, Your Honor, I had not noticed. And you know what she said? This is the funniest thing a judge has ever said to me. I love this judge, by the way. She's the best. She says, Mr. Runkle, I remind you that you have a duty of candor to this court. She's like, I was being real strict with you. And I'm like, I hadn't noticed. She's like, bullshit. It was glorious as a little moment there. She's like, I just wanted to let you know that part of the reason why I was holding you to these strict standards is because of who your principal is. But you have behaved well and ethically and responsibly in my court. And so I just want to let you know I'm going to ease up on you a bit. But that doesn't mean you're going to get away with anything in my court. And I was like, I understand, but thank you. And yeah, she's been fantastic. Are these kinds of ex parte communications with the court legal in Canada? Yes, because it wasn't about any specific case. It's just the judge chatting with me, right? So it's just the judge and I having a chat. I'm allowed to chat with judges, but I can't talk about a case I have with the judge. You know, that's the difference, right? So, all right. Where were we? Oh, right here. So when a lawyer presents false information to a court, that lawyer violates his duties. Even with recent advances, no reasonably competent attorney should outsource research and writing to this technology, particularly without any attempt to verify the accuracy of that material. I say again, no reasonably competent attorney should outsource research and writing to this technology, particularly without any attempt to verify the accuracy of that material. I mean, who would be dumb enough to use ChatGPT or Grok or whatever? Oh, my camera has done a thing, without actually even checking the output, right? Because if you did that, you could end up with it putting all sorts of stupid things in there. So yeah, it is incumbent upon all participants to adhere to professional standards governing their work. And then they cite to the federal rules of civil procedure. They note, as the defendants have noted, there are several troubling issues regarding the citations in Mr. Mattiacci's brief in support. Those issues include the persistence of fictitious cases, quotations that do not appear in the reference cases, and cases cited for support that simply do not even come close to involving the issues being cited for. The issues with Mr. Mattiacci's briefing appear to be violations of Rule 11. But what the court finds even more troubling are Mr. Mattiacci's attempts to shift the blame for such mistakes. In his reply brief, he includes a long soliloquy on the perils of solo practitioners, claims that the errors in the citations are minor, attempts to point to other purported misconduct by defendant's counsel, and claims that these are procedural distractions. You see, this is a lawyer who's not taking responsibility. And if you don't take responsibility when the crow is young, then you may get the opportunity to eat the crow when it is old and tough. And if you don't eat the crow when it's old and tough, then you get to eat the crow after some other carnivore has eaten the crow. And at that point, you're just eating shit. Like, yeah, you don't want to be there. Yeah, I see people mentioning somebody or multiple people in the chat. We're going to give David a pass today. David gets a pass, and the reason why David gets a pass, we're not going to criticize him. I'm not going to throw shit at him. He's had a personal tragedy in his life. It's not my place to, anything. I thought about reaching out, but quite honestly, I don't think he wants to hear from me right now. But, a man in a moment of grief deserves to be left alone. So we're going to do that. We're going to give him 2 weeks and a month, something of just ceasefire, folks. Because, I cannot imagine being where he is right now. And David, if you ever see this, all you've got is my sympathy right now. And we are just going to, it is ceasefire. This is Christmas on the front lines right now. That's where we're at. The other thing is at the meetup, anyone who wants to show up is invited except one. That person's got no business. No business showing up and should not show up. So somebody says, who is David? David Gingras. He's a lawyer. There are reasons to criticize him, but another stream elsewhere. No, we good. All right. Mr. Mattiacci is an attorney, and as such, he's subject to the same duties that guide every attorney. At the very least, the duties imposed by Rule 11 require that attorneys read and thereby confirm the existence and validity of the legal authorities on which they rely. Indeed, there is no other way to ensure the arguments made based on those authorities are warranted by existing law or otherwise legally tenable. Mr. Mattiacci cannot escape these duties by pointing to the duties of others, or ascribing a label to his errors, or by claiming that pointing out his errors are attempts to misdirect. Now I'm going to have people going, Runkle, are you sober? I am 2 drinks in. But my tripping over myself is because my brain is locked onto other thoughts, and I got the attention deficit thing is kicking hard into gear. So this is not the first incident. So the thing my brain is locked into is just the the thought of if I lost Mrs. Runkle, because I would not know what the fuck I would do. You guys would not see me for 6 months. I would just be I can't, and I would just be I'll run a video every once in a while that is just hey guys, I cannot, so that thought is an intrusive thought and is stuck in my head, and yeah, I don't like it. I want it gone. It's like that thought can just go away, please. But that's kind of how my brain works. Is you think of something, it sticks, and attention deficit is kind of a badly named disorder because everybody like attention deficit. You think it means you don't have much attention. It's not a lack of attention. It's a lack of control over your attention. So, like, sometimes your attention just grips in on something that is like you don't want it to, and you can't let it go. And it just like, and that's the problem that you get sometimes. It's just like, your attention devours you on something else. And, it's not always a great place to be, if that makes sense, because sometimes that somewhere else is not a happy place. So yeah. So this is not the first instance of Mr. Mariachi demonstrating ignorance or conscious disregard for the local and federal rules that govern practice in federal courts. If you ever really want to get in trouble as a lawyer, it's not just fucking up. It's fucking up twice. In a previous order, I stated that plaintiff's counsel has been given a great deal of lenience by the court in regard to his adherence to federal rules of civil procedure and local court rules. While these errors have been harmless in the past, the court will no longer grant plaintiff's counsel the benefit of the doubt. In this vein, both parties are expected to strictly comply with this order, the federal rules of civil procedure, and the United States District Court for the Middle District of Pennsylvania rules of court. If they do not, they are on notice that the court is prepared to consider other appropriate sanctions. It is now time for Mr. Mariachi to answer for what appears to be violations of the federal rules of civil procedure. The court's like, I gave you a warning that if you fucked around, you'd find out. Now is the time of finding out. Y'all about to find out. If I go my entire career without a line like that appearing in my in like a ruling about me, I will be so fucking happy. I do not need anything like this to ever happen to me. And yeah. All right. I see people like still talking about DG. We're just gonna move on. No more, like, leave him alone. Leave it out. Like, don't make me come over there. So therefore, Mr. Mariachi will be required to show cause why he should not be sanctioned for an apparent violation of Rule 11. He will first be required to address this in a brief, and then will be required to attend a hearing on the show cause order. Oh yeah. Yeah, he's gonna have some moments. I was ordered to show cause once, but I hired a good lawyer and it was quashed. I mean, it happens where you get an order, but the quashing is good. Let's do a swoop. I see people asking for a swoop. We'll do a swoop and then a goal for a dog story. All right. I don't know how that. So I had a goal for the. The fantasy closing. I don't know how far that got. It shows me 0 out of 10, but did we get there? Tied? Can you let me know like where we're at on that one? And I set a new goal now. The new goal is for a pupper story. Because Mrs. Runkle was away this weekend. And the pups had thoughts. They had opinions. They had feelings. And yeah. All right. I see We won Speak Your Fever's dreams to reality. Tide, can you confirm the goal was hit? We made goal. Okay, Tide is saying goal was made. I can give the rant first. So here's the rant. So we're talking about the Aaron Spencer case. Now, if you don't know the Aaron Spencer case, the Aaron Spencer case is a troublesome one. Runkle, is the Buick still stuck in the land? It is. It is totally stuck. It is totally stuck. So Aaron Spencer, what happened is his child was 13 years old, little tiny kid. And she gets into a relationship, which I put in quotation marks, because a 13-year-old isn't in a relationship. A 13-year-old is being abused by this 67-year-old dude. LMAO, it's still there. Yeah, it is still there. Oh, yeah, I should give the warning. Content warning. So this guy is arrested and charged and gets released on bail. So, of course, he stays away from the little girl, right? Well, no, that is not what he does. The father of this girl wakes up and finds that she is missing. And so he has a little suspicion-y poo about where she might be. And so he goes and looks into, like, where could she have gone? And sure enough, he goes looking and he finds the 67-year-old driving with her, like she's in his truck. And so he rams this guy's truck. And then he, he stops, he gets the truck off the road. He goes to confront this dude. And according to his version, and I don't think there's a whole lot of reason to doubt it, but the 67-year-old dude, who is a Mr. Fosler, rushes him and then ends up getting some additional aeration. He is given the gift of lead, vitamin PB, and he dies on scene. So, Mr. Spencer is now charged with murder for the killing here. And the prosecution's theory of all of this is that basically that that the daughter sort of snuck out and, is able to make her own decisions at the tender age of whatever the fuck teen. And whereas, like, actual human beings are like, holy shit, this is a child. And this guy was looking to, to do horrible things with a child. So Mr. Spencer is charged with the killing of Mr. Fosler. And he's going to go to trial. Now, the funny thing is that Mr. Spencer is the nominee to be sheriff, and so is likely to become the sheriff. But yeah. So anyway, this is the fantasy closing, the closing argument that I think his lawyers would like to give, and that I would like to give if I could, but that the court system says no. Because the court system does not allow you to do things like invite jury nullification or, certain kinds of rhetoric. No, this is in Arkansas, I think it is. So, All right, here we go. Here is the speech. Here is the close that I would like to give. And I'm going to censor some words out. I just need you to tell me. I need you to tell me if this works. It's not even working on my end. Why? Hold on. I got to bring up a thing. So, are we not mentioning his law enforcement background? Yeah, the 67-year-old has a law enforcement background. So, yeah. Where is my bleep button? My bleep button needs to be a bleep button. And I'm just trying to fire it up here. 1 second. Is the car becoming a feature of the property now, or continued rescue plans underway? With our big tractors, my dad always said, just be gone when I get home if you get it stuck. Encouragement to stop before it's buried. It is stuck. It is good and stuck. And so we got to get that done. I got to figure it out. But the owners, it's actually stuck on the neighbor's property's land. And so they have asked if I can let them try to recover it. Right. Why is my Stream Deck not stream decking? Are you guys hearing the noises? No, probably not. Oh, yes. Fowler also had a dash cam in his car, and the cops lost the ST card. Yeah. All right, so we don't have that. Where's my goat? I saw somebody suggest using the goat for censorship. That's a good idea. If I can find the goat. I got too much stuff in here. Where's my goat? I gotta get the goat. That's not a goat. That's hot sauce. That's also not a goat. That's hot sauce. That's not a goat. That's ammunition. It's like I have way too much junk in here, and I can't find my goat. I can't even find my violin. This is a tragedy. Aha! Found the goat. Found the goat. And it's the Christmas goat. Okay. So we are going to use the goat for the bleeps. Because some stuff I got to bleep out because otherwise, YouTube, etc. will, will have an issue. So, all right, here we go. Ladies and gentlemen of this jury, I want to thank you for being here. The facts you've heard cannot have been easy to hear. They certainly cannot have been easy to live, especially for Mr. Spencer and his daughter. Let me be clear. Aaron Spencer shot Michael Fosler. He shot him until he was dead. And if he hadn't, and I'd been in a position to, I would have shot Mr. Fosler dead myself. I suspect each of you are thinking you would too, for your daughter or for Mr. Spencer's or any other little girl in this state. Mr. Fosler was he had Mr. Spencer's daughter. He had her in his truck, taking her away to do it again. Mr. Fosler died in a ditch, which is where he ought to have been buried. The prosecutor is going to have some more to say to justify this travesty of a prosecution. You've got to listen to that and hold your bile. But what matters is what happens after that. You'll go back into the jury room to deliberate. You'll have to make the decision about whether you can look your fellow jurors in the eye and tell them that Mr. Fosler is a victim. If you do, you'll have to walk back into this courtroom in front of everyone in this courtroom. And when I poll the jury, you'll have to look us all in the eyes and tell us that you think that Mr. Fosler is the victim here, not Mr. Spencer or his daughter. You can look us all in the eyes and tell us whose side you're on. Or you can tell the prosecution that you stand with Mr. Spencer and his daughter. You can tell the prosecution that this was wrong, that they're on the wrong side, that they should be protecting people like Mr. Spencer's daughter from not protecting from the fathers of the little girls they are preying on. And if, as I'm sure you will, you acquit Mr. Spencer, the prosecution may want to speak with you to ask you where they lost this case. You can tell them that they're asking the wrong question. What they should be asking is where they lost their moral compass. I'm going to wrap it here. I know you don't need me to tell you how to do the right thing, and I have confidence that you will. Thank you. And for StreamYard purposes, clip that. We're testing. So now, I mean, absolutely not allowable under like all the rules, because you know, you just can't. But I'm sure it's what they'd love to deliver and just be like, yeah. So why not allowed? Well, first, the argument invites jury nullification, and you cannot invite jury nullification in Arkansas. Juries have the power to nullify if they want to, but you can't tell them to do it. And yes, you also cannot tell them to rule based on things like, you can't tell them to rule based on like, you will be embarrassed to look at your fellow jurors and to look at all of us in the eyes. You cannot shade the prosecution, right? You cannot tell the prosecution, like, you can't say the prosecution is, you know, being a bunch of horrible people. So what they're going to have to do is they're going to have to go over like the facts and argue the law. And that's, you know, so all of these things are things that, like, if you delivered this close to the jury, the prosecution would stand up and they'd get a mistrial. Right? So yeah, is nullification when they say they can't make a decision? No. Nullification is a, you know, nullification is the situation where they believe that the accused is guilty and they're convinced beyond a reasonable doubt of the accused's guilt, but they refuse to impose the penalty. I should note, jury nullification is actually one of the things that is the reason why there is a constitutional right to a jury in the United States. Because one of the classic examples of jury nullification is poaching. So back in the day, the king owned the deer. You were not allowed to eat deer. You were not allowed to hunt deer. They were the king's deer. But you know what hungry people do? Hungry people eat the deer anyway. And so what would happen is you'd have some starving family, and the father of this starving family gets brought in, and like they literally find the guy with a deer on his back and like blood on his you know, on his back, and you know, they eat, like, they bring him in, and the trial is like, he had the deer, and he's like, I shot the deer. I was going to eat the deer because I'm starving. My kids are like starving to death. I was going to eat the deer. And they would be like, jury, the punishment for this is death. We require that you sentence this man to death. He has admitted the crime. We found him with the deer. We somehow, notwithstanding the fact that this is the medieval era, have video evidence of him with the deer and DNA proof. And the jury goes, nah, he didn't do it. That deer just unalived itself and jumped onto his back. And this is all a horrible misunderstanding. Let my dude go. Fuck y'all. Let him go. And the government would be like, but he admitted it. And they're like, don't fucking care. Didn't happen. I don't think there even was a deer. I don't know what a deer is. Fuck y'all. And the thing is that sort of thing, that was the kind of thing that was like, that led the founding fathers to think we need a right to a jury. Because at some point, our government may lose its way. Our government may start doing things that we consider evil or wrong. And we need 12 ordinary people to be like, we are okay with this. And if you can't find 12 ordinary people who are like, we're okay with this, you don't get to send a man to jail. So, you know. Yep. In Canada, there is a famous case, the Morgentaler decision. It is a case of jury nullification. The jury refused to convict Dr. Morgentaler, notwithstanding the fact that they ran like 9 trials. But there are some dark sides to jury nullification. Worse than Joe Rogan notes, jury nullification also let Klan race murderers walk free. Yep. The other side of jury nullification is that there is nothing to stop juries from just deciding to convict somebody even though they don't think the person did it. And like, that's the problem Chud the Builder has, because Chud the Builder, even if the jury thinks it's self-defense or thinks they have a reasonable doubt on self-defense, they might decide to convict the guy just because they're sitting there going, fuck Chud. So, I mean, yeah. Runkle, do you think dismissal or nullification is best for Spencer? Either or. 6 of one, half dozen of the other. He's fine with either. So, yeah, it's a whole thing. All right. We previously did a viewer discretion content warning. We're going to do another one. I'm also going to point out that this is all right. Fair warning, this story is awful. This story is so awful. But it's about a lawyer. So we're going to cover it because sometimes we cover terrible things that lawyers do. Houston lawyer charged with, y'all can read it, after wife caught him, y'all can read it, family dog. A 56-year-old Houston attorney has been charged following allegations of animal abuse involving a family dog, according to the court documents filed in November 2025. I haven't been able to get the court documents at this point, but yeah. He has since been released on bonds set at approximately $7,500 and is due to appear in court on Tuesday. According to court documents, the allegations came to light after Swain's wife reviewed footage from surveillance cameras installed inside the family home during renovation work. They're like, we're going to catch the contractors doing bad things. And instead they catch this guy. The footage allegedly showed behavior involving the household dog named Shipley, which she then reported to the authorities. So they did not give a whole lot of details. One news article noted that the police stated, and this is a quote, I apologize for the quote, "We are unable to disclose the details other than to say the incident involved licking." I can tell you this this divorce filing writes itself. And every lawyer who is against this guy, the internet suggests that he primarily does real estate, probate, and estate planning. So I guess he probably doesn't do a whole lot of litigation. But like any opposing counsel is going to be like, so, dude, what the fuck? And I feel like maybe he should be doing less probate. He says, Tyler has earned the reputation amongst his colleagues as a skillful negotiator and navigator through the courts in all matters related to probate. Again, no probate. You cannot probate anymore. And I feel like he has earned a reputation among his colleagues of an entirely different sort at this point. Because if I was his colleague, I would have some fucking opinions at this stage. I think I've got the right Swain, but yeah, dude, time to take your webpage down. Just like, yeah. Is there any chance the wife is lying? Apparently, she has provided the. Apparently, she provided the video to the officers. So I don't know. Oh God, does he have Google reviews? Oh God, I hope not. Yeah, that. It's a horrible story, and the thing is, you know, if you've got lawyers behaving badly, they deserve to get effed. That, yeah. GameCon Canada has a VIP pass. I don't think I'm going to do a VIP pass. That sounds ridiculously expensive and pointless. It's $400. Fuck that. It's like, nah. I got to decide if I'm going to do a thing there, but yeah. All right. Yeah, I got to make decisions as to what I want to do. All right. What else did I say we would talk about today? I got a whole bunch of a whole bunch of things to cover, but I feel like we've been at this for 3 hours. So what else have we covered? Let's see. Magician lawyering. I don't know if magician lawyering is that. Chat, you got to let me know. Do we want to cover magician lawyering or lawyer getting shot? What are we thinking? Magician or lawyer getting shot? Please find something good to end on. That sounds like a vote for lawyer getting shot. People are saying magician. Okay. We can look at the magician case here. I see some people saying lawyer getting shot. Do I need to do a poll? It looks like magician is getting. Tell you what, we'll do magician, and then we can decide about the lawyer getting shot. Yes, there's new stuff in the magician lawyering, so we could talk about that. No, but I don't have the right filing. This is the opposition. I don't want. I'm going to cover the opposition next week because it's 30 pages long. I am going to instead try to cover the notice. Where's the notice? Here we go. Nope, that's the dismiss. Where's the notice of motion? Where's the thing I want to go over for judicial notice? Oh, the thing I wanted to go over is in a different case. That's why. I'm like, hey, what's going on? I got really bored with the very valid legal case on Magic last week. I apologize. Or is it a magician getting arrested for shooting a lawyer? No, what's happening in this case is that one magician is suing another magician for being a wanker. You were going to tell us a story about your pups when Mrs. Runkle was gone this past weekend. Did we hit that goal? We did. Okay, so I'm going to close out the content warning. All right, so the dog story. This is a fun dog story, not the other one. So Mrs. Runkle was gone this weekend. She was off doing Girl Guide things. And so while she was gone, the dogs were very opinionated about the lack of Mrs. Runkle. And I mean, I get it. I also have strong feelings about the lack of Mrs. Runkle. Those strong feelings are basically Mrs. Runkle should always be around, but I do kind of have to balance that with the thing about, like, you know, she gets to have a life and she gets to have, like, things. So Zora had a coping strategy. Zora's coping strategy for the lack of Mrs. Runkle was that she wanted to look for Mrs. Runkle a lot. So what she does when she's looking for Mrs. Runkle is she'll go out to the backyard, because we have like rear parking, so, and she'll run out to the fence following the smell trail of Mrs. Runkle, and then sniff at the gate and be like, okay, she's gone. But she'll do that for like a day and a half. And after that, she loses the scent. Like, there's just not enough smell of Mrs. Runkle walking down that trail for her to follow it. So instead, once that day and a half wears off, she'll go outside and she'll do like a search through the backyard looking for Mrs. Runkle. And then once she's done that perimeter sweep, she comes back in and she's like, okay, she's not there. I'll check again in another 20 minutes. Now, Potter has a different strategy because Potter understands that Mrs. Runkle is not around. But Potter gets really needy. Potter gets to the point where he's like, I want like reassurance that you actually like me and are not going to because Potter gets nervous at the notion that like people might abandon him, so he's like, I require some reassurance. You must convince me that you are not going to abandon me forever. So I was there like having a nap, and Potter comes up and he sticks his nose right into my armpit, which is like not a pleasant place for a cold, wet dog nose. So now I'm awake because like boop right into my armpit, and I'm like, dog. And he's like, I need love. This is Potter, by the way. So Potter's like, I need love. And so I give Potter some scritches, and he's like, okay. And then I think Zora climbs up into the bed because Potter does not like getting into the bed to snuggle. Potter is very much I am on my own kind of dog. So Potter, I assume that it's Zora that's climbed into the bed and is snuggling. And then Zora climbs in. And I'm like, oh, wow, Potter is deciding he needs to snuggle me, which he never does. He never snuggles, like, at all. And I was just like, oh, man, this is the best thing ever. And I've got both of these. So I'm, like, sandwiched between these dogs. We're like, you cannot leave. And I'm like, okay. Okay. What is it? Just notice that the toy has the tag still on. Potter is also an absolute suck because any toys that have like a face, Potter will not mistreat. Potter will absolutely like defend that toy. So like the elf toy, it's intended to be a chew toy. What does Potter do? He loves that. He just takes it up into the bed and he snuggles with it, unless somebody else is in the bed. And then he's like, I'm out. We're not doing a snuggle thing. So he'll like play tug with like a rope or like a little rubber tire or like those kinds of things. But he will not play tug with like the elf toy. So if I have the elf toy and I hand him the end and try to play tug, Potter will just be like, I refuse. I'm letting go because I don't want to hurt the toy. The toy is too precious, and I cannot let it come to harm. And it's so freaking cute. But he's just like, no, we do not tug the cute toys. So yeah, if you want to play tug, you got to use a rope, because the rope, he's like, that's fine. But anything else, he's like, no. All right. So that is the dog story. We got this one here, which is Masika Magic, Yigal Masika versus Penguin Magic, Craig Petty, and Doze 1 to 10. Now, I feel like Petty is one of the best names for a lawsuit ever. But so this is the plaintiff's opposition to Craig Petty's motion to dismiss. All right. So let's let's dive in here. Because they throw some fire. I kind of like both lawyers on this one, although this one, I kind of feel like they're doing some weaselly things as they go. So defendant Petty has unloaded a large pile of irrelevant exhibits upon plaintiffs and this court. I'm like, no, we're going to have this kind of shady. I'm here for it, folks. The motion comprises 35 filed pages with large exhibits. On top of this, Petty submits separately a request for judicial notice with 42 individual exhibits, most without proper authentication, amounting to 334 pages in support of a motion to dismiss under the Federal Rules of Civil Procedure. The memorandum, docket number 50, expanded the 7,000-word briefing limit to unfairly give an advantage in briefing his motion. It is noted that Petty's motion brief, number 50, lacked the certificate of compliance required by the rules, while Petty's brief seems to have a word count of 7,246. And you might be saying, who gives a shit about an extra 246? Courts may or may not. Some courts are real strict about page limits. And when I say real strict about page limits, I have literally watched a court take a guy's, like the brief, count off the 30 pages they were allowed, and then rip off the rest of the brief and toss it away and say, you get to argue these sections. I have seen them literally do that, where they just tear off everything after the limit. And if you haven't made your argument in the first stuff, you're just, you don't get to make it. So, yeah. Despite the expansive volume wielded against the second amended complaint, as his co-defendant states, but volume is not sufficiency, defendant Penguin Magic Incorporated's notice of motion and motion to dismiss. So, yeah. All right. Factual background. Yigal Masika's reputation. A California court found that plaintiffs who make equipment for a niche market but do not advertise or sell to the general public were found not to be all-purpose public figures, as they lack pervasive involvement in the affairs of society. Now, here's the thing. He might actually be a limited purpose public figure. So you being not an all-purpose public figure doesn't mean you can't be a limited purpose public figure. And so the difference is like, just a general, a public figure in general is somebody who is like Johnny Depp, right? Like somebody who is so famous that just like everybody talks about them, right? So, Johnny Depp, Trump, somebody you would recognize who plays sports. These kinds of things are people that you can sort of gossip about. But you also get the category of limited purpose public figures, right? So if you are in a scenario where you have like, so a limited purpose public figure might be like, let's imagine you have a dispute with another person and you put out like a press release about your dispute with the other person. Well, at that point, you might become a limited purpose, and you almost certainly do become a limited purpose public figure in the sense that people can discuss you in the context of the thing you raised as an issue of public importance. But that doesn't mean that every aspect of your life is necessarily connected, right? So, like, if you think of the Karen Read trial, for instance, Turtle Boy. Turtle Boy, you might say, is a limited purpose public figure with the, in the sphere of like, the Karen Read trial. But that doesn't necessarily mean that you can, that you can say things about him outside of that. That might be subject to defamation, right? So you got to be careful about that. And the other thing is you've got to consider the question of like, if you want to make public statements, what do you want to be a public figure in relation to? Because if you start putting things into the public consideration then you may lose certain protections with respect to those, right? So, like, for instance, if you, you know, if you tell everybody in the world that you are, like, you know, the bestest ever cook, then it might become a limited purpose public figure as to your cooking. And so somebody might, for instance, be able to then, you know, say something along the lines of, you know, what is it? You know, something about your cooking. What the Rumble stream apparently ended, and I don't know why. That is awkward. That's probably a StreamYard thing, but weird. So, you know, just be careful about all of that. All right. So Masika's reputation is tied to the commercial sale of his inventions within a niche community, which does not amount to the general fame or notoriety required to strip plaintiffs of private figure protections. So, the thing is that magicians, how do I put this? Most magicians are not inventing their own tricks, because inventing a trick, inventing like a, you know, a gimmick, inventing whatever is a very specialized skill. And, you know, it's a situation where the, you know, it's a thing where it requires like different levels of skill than performing does. So there are some people who are very good performers. They've got like very good stage presence. They're very good at all of these things, but they don't like, you know, they might not be able to invent a trick. They might not be able to invent, you know, any of these things. Whereas you get like the top tier of like, you know, magician, you know, things are the people who not only are good performers, but also are able to invent moves, invent tricks, invent these things that no one else knows and no one else can do. So, for example, Penn and Teller. Penn and Teller have some tricks that like nobody else does because they invented it. They keep the secrets strictly under wraps and nobody else knows how they work, right? Whereas you get other people who like do things, and when those people are doing tricks that, you know, that they didn't invent, you know, those folks buy them from like specialty retailers. And so the specialty retailers basically market stuff to just the magician community. And the reason why they market stuff to just the magician community is that these tricks, these tools lose their value if they become known to the general public. Because what you don't want is to pull some neat, you know, trick that you're doing is like street magic. And some dude is like, oh yeah, I bought the same trick. Here's the webpage I bought it from. They do not want that. You know, like, that's a thing they just do not want in the slightest. So they try intentionally to stay under the radar. Yigal Masika is never going to sell his shit at Walmart. So that's really what they're talking about here, right? It's a special sort of thing there. So what they're saying is Masika's reputation is tied to the commercial sale of his inventions within a niche community, which does not amount to the general fame or notoriety required to strip plaintiffs of private figure protections. I don't know that I agree with them, but Yeah. The videos at issue. A. The desolation of Yigal Masika. He attempts to reference a text message exchange between Craig Petty and Yigal Masika, but studiously avoids providing the full contents of the text message chain. And I'm like, this is bad, shitty writing. And the reason why I say this is bad, shitty writing is that they start the paragraph, they start the section with he. And I'm like, who the fuck is he? Okay. I'm already lost. Don't do this. So filed concurrently is the declaration of Yigal Masika producing that text message conversation. Below the details of that conversation, wherein Petty acknowledged that Yigal Masika's patent application did indeed cite prior art that he claims in the later video Masika intentionally hid, and thus Masika's invention was stolen. Petty knew the falsity of his statements as of June 27th, 2025, but contemplated the video for 2 weeks, then published knowingly false statements on July 4th, 2025. So the issue here is the question of actual malice. Do you remember the Johnny Depp trial with actual malice? Because if you've got somebody who's a public figure, actual malice isn't like mustache twirling evil. Actual malice is, did you know that what you said was a lie? Or did you have a reason to doubt it that you believed, like that you considered a reason to doubt it, and you intentionally failed to investigate? Were you reckless? But simply not believing that the opposite is true is not actual malice. This is one of the reasons why being a public figure is kind of a risky thing, because if you, if you're a public figure, then in order for defamation to be established, it's got to be with actual malice, which is so fucking hard to reach. It is really difficult to get to actual malice. And, that, because how do you prove somebody knew it was false? How do you prove they knew it was a lie? Unless they said somewhere that they knew it was a lie, unless they put that in writing, you're going to have a hard time. Did Ian cover the Cardi B lawsuit? No. So Petty could have produced a text message conversation in full, but strategically did not. This is not the first time that Petty strategically burdened this court while withholding evidence contrary to his assertions. On February 18th, 2026, Petty filed a motion for extension, seeking to avoid responding to the first amended complaint, claiming that Petty did not know that he was properly served. In fact, 5 days earlier, on February 13th, Craig Petty published a YouTube video, sued for speaking out, and a Give Send Go campaign displaying the first image of him holding the first amended complaint and stating around 117 through 125, I was served with a 105-page complaint. It was hand-delivered to my office, 105 pages. If Petty had complied with the local rule 7.3, I could have informed counsel of Petty's public display of himself holding the served complaint. Petty's penchant for not being truthful is established. This is the problem with being a YouTuber, right? Is that anything you do, you're going to talk about your life. You're going to create a record. And, if somebody's being diligent, they might go through your videos and find shit. So, I got to worry about that too. Everybody's got to worry about that. Especially when I talk about, like, my dogs being cute and, like, my wife being amazing. Because, there's got to be some scenario where somebody could use that against me. I posted a thing on Twitter, just as a random aside. I posted, like, guys, you've got to learn to cook, because there's guys out there who don't know how to cook and think it's their wife's job. And the thing is, your wife doesn't want to learn or doesn't want to cook either. And cooking means that you get to eat the shit you want to eat, how you want to eat it. And you get to do it like whenever you want. And you get to look awesome when you do. Because like Mrs. Runkle came home yesterday. And she was tired as fuck. She's like, I am exhausted. And I was like, I'll cook. And she's like, really? And I'm like, yeah, I'll cook. And she's like, thank you. And I'm like, okay, cool. Like, I cook, I like cooking. And she's like, and we've got to use up this ground beef because I have a whole bunch of ground beef and we got to use that up before it goes bad. And I was like, yeah, I think I can do that. What I didn't tell her, what is my secret here? Secret. I had a hankering for burritos. And so she's like, hey, like we have to use up the ground beef. And I'm like, twist my rubber arm here. Like I am, I will totally make some burritos because I wanted the burritos. And, so it's like, it's an absolute, it feels like a cheat code because you cook. Everybody likes being cooked for. Everybody. And, like there's nobody on the planet who doesn't like being cooked for so long as the food is good, right? So by being a cook in the family, you generate goodwill every time you do it. And you get the benefit of whatever it is you're making. So yeah. Drex's Unused Baldo says, my go-to has always been the Shankla of Destiny never misses, and the Dildo of Consequences rarely comes with lube. Banquet of Consequences pleased me greatly. By the way, why was Dildo okay but not Baldo? I mean, I don't know what Rumble's rules are, so yeah. My only problem is my wife keeps trying to insert healthy ingredient substitutions, which do fuck all to change the nutritional value of the food, but double the overhead. It's fucking beefaroni. Relax. Did you love the burritos? She was so tired. Mrs. Runkle was exhausted coming back, and I think she loved that she was not cooking, but beyond that, I don't think she was tasting it, honestly. I probably could have served her like seasoned wood chips, and she would have just been like, thank you for not making me cook. One of the things I'm doing for the Extra Life fundraiser. Extra Life fundraiser is going to be in November-ish. And so one of the things I'm going to do is there's going to be a donation level that if we hit that, then I will, or if you donate, I'll probably set it at like $20 or $25 or something, where if you donate $25, you will get a copy of the, and it'll be a digital copy, but you'll get a copy of the, of this cookbook. And so the cookbook is going to include, it's going to be written in like Runkle style. So it's not really going to be like, here's how you make things. It's going to be, here's Runkle being a cheeky little shit in the context of food. But you'll be able to figure out how to make the food from reading Runkle being a cheeky shit. But, it's going to have Runkle style of, all of that. So, what is it? Yeah, but one of the recipes that is going to be included is one of the recipes that is going to be included is ratatouille. And the reason why ratatouille is one of my favorite go-to recipes is it's easy and everybody Jolene, email me. I will send you a proper message. So it's easy. It's you cut a bunch of stuff up and you cook it for a while. It's a stew, right? It's healthy because it's all vegetables. It's vegan if you leave out Parmesan cheese, or it's vegetarian if you put Parmesan cheese on it. And it's also hypoallergenic. It has like all of the ingredients are things that people are rarely allergic to. And so it is my go-to recipe when I have people coming over who I don't know. So like at one point somebody had like a new partner, and they were bringing the new partner over, and it was around dinner time, and I was like, fuck it, I'm making them some food. So I went and made the ratatouille, and they came over and they're like, oh, I've got allergies. And I'm like, here's the full ingredient list. They're like, oh shit, I can eat this. It's vegan, it's gluten-free, it's hypoallergenic, it's like everything. And now it's better if you serve it with a loaf of bread. It's better if you serve it with a loaf of bread with butter like on it. It's better if you put some Parmesan on the top, but like you don't have to. It's good. And yeah, except for nightshades. If you're allergic to nightshades, you will have a problem. But yeah. All right, so we'll do that. There's a few other things that I'm throwing in there. And yeah. And I'm dying for your ratatouille. The ratatouille, I will note, the ratatouille recipe is on my locals page right now. So if you need that, now, you can get that now. But some of the other recipes are not there. I am working at this point to I'm finalizing a bitter melon recipe. The bitter melon recipe is I'm trying to get it done. The reason why is that normally when I cook bitter melon, I cook it the same way I cook chicken hearts, and it's like I don't feel like I should give you two recipes that are the same recipe, but so I will it'll note that you can make the bitter melon in the same sort of sauce as the thing, but I'm trying to make a variation of it that, yeah. What is your email? Runkle of the Bailey, all one word, @gmail.com will reach me. All right, back to magicians. I'm having a very attention deficit day today. I don't know if anybody noticed. I feel like I may have gotten away with it. And chat's like, Runkle, you got away with nothing. So, yeah, I saw people asking, somebody was saying invite EDB. EDB always gets an invitation, but whether or not EDB comes is up to EDB, and I cannot force EDB to show up. So she will get an invitation, and what she does with that invitation is her call. That's all I can do, right? I can't promise you anybody. So yeah. So Craig Petty discusses controversy with Yigal Masika. The description of this video publishes a defamatory statement against plaintiffs. Eric Tate, for the first time, shares the story of when he wrote ad copy for Yigal and how it didn't end the way he had hoped. The Penguin Magic video and the channel overall is branded with Penguin Magic's branded marks, is monetized through YouTube and embedded links linked directly to Penguin Magic's product pages, including products competing with plaintiffs, and used to drive traffic to Penguin Magic's platforms and sales funnels. I mean, they do that for everything, right? This video also republishes Craig Petty's defamatory The Desolation of Yigal Masika video via the displayed active link and excerpts from Petty's video. Kimchi the Forensic Homeopath says, how much can I give you for your ratatouille recipe before November? I have a family full of dietary restrictions and severe food allergies, and I'm running low on stuff that works for everyone. If you go to Locals and you do a search for Runkle of the Bailey, you will probably find my Locals page. If you go back, you can find it there. If you shoot me an email, if you can't find it, I will send I'll send a message and be like, here it is. What is Locals? Locals is a page. It's a thing. So the Penguin Magic video was published on their official Penguin Magic YouTube channel that prominently displays Penguin Magic's name and logo, and that links viewers directly to Penguin Magic's retail website and product pages. I'm guessing that is every single thing that they publish is probably linked to their website and product pages, as opposed to specifically the stuff about Masika. That's my guess, right? Beneath or near the videos, viewers are encouraged to visit Penguin's site, and links to products, including Craig Petty's releases and competing products, appear in the description or on the same page. Again, I'm pretty sure that's everything he does, right? Because Craig Petty is another person who makes magic shit. Sued for speaking out, February 13th, 2026. In this February 13th, 2026 video, Petty doubles down on the same defamatory statements from his Desolation of Yigal Masika video after having been served with the First Amendment complaint and demonstrated actual malice. And there's a footnote. The footnote is just C paragraphs, whatever. Okay. The thing is it's not actual malice to repeat a claim after the other side disagrees with you. Because it's not just actual malice to be like, we told them they were wrong. Okay, they don't necessarily have to believe you. Actual malice requires a bit more than that. It requires a situation where you're like, okay, but, I actually believe there's a concern here, right? Because if you get to the point where you believe that they might be true and you are in a position where you have doubts about what you're saying, then you can be into actual malice. Or if you know that what you're saying is false, you can be into actual malice. But if you're just if it's just the other side said some shit and I thought it was bullshit, that probably doesn't put you into actual malice. Because actual malice is super fucking hard to get to, right? It is really, really hard to get to. And, it's so hard to get to actual malice. Just insane. All right. Cleopatra, I'm glad to hear it. I'll still donate even if EDB doesn't make it. It's a good cause. 2 or 3 years ago, she made it for 15 minutes towards the end. Since then, she hasn't been able to make it. So I would not hold your breath, is, I guess, what I'm saying there. So, all right. Petty sued for speaking out video demonstrated actual malice when he publicly stated, I stand by that opinion, immediately after confirming that he was served with a 105-page complaint. That sounds like the opposite of actual malice, right? Just because one side says, if I'm imagine Michael Jackson is alive, right? And you're like, I think Michael Jackson is touches kids. And then Michael Jackson personally shows up at your house, does a moonwalk, and says, I didn't touch those kids. And you're like, cool. I don't fucking believe you. That doesn't make it actual malice. You're entitled to be yeah, you said some shit and I think you're wrong. That is not actual malice. Oh my God. Why? Why are lawyers like this? So, yeah. Dog Mom, can't afford a membership right now. Then don't get one. But want to let you know that I love you, Runkle. I do not gatekeep legal discussion behind memberships. So like this stream will never cost money. What I sometimes put behind a member wall is, is things like if I'm just doing like a leatherwork stream or just like a hangout kind of thing, sometimes I might put that as a members only. But, I'm not going to do a members only for discussion of legal cases because I think that people should have access to this kind of discussion. And, so even if I make no money, like if there's not a single membership, not a single super chat, I suppose if I make nothing, I might eventually be like, well, shit, I gotta go and find another job. But, so long as I'm like afloat, I will not, I'm never going to do something like I'm covering this big case. Like during the Johnny Depp trial where I had like juror, insights and juror observations that nobody else had because, I was there and, some days nobody else was there. I didn't put that behind members only because like I want to share. And I mean, let's be honest. The economy is shit right now. Filling up the Buick, I hit $100 filling up the Buick. And then I got it stuck at the land. So that's $100 worth of gas that's just stuck there. But like, things are fucking expensive right now. Like ground beef, you go and you buy the ground beef. It's expensive. I'm doing okay, right? And, but I know that there's lots of people who aren't. And if you are not doing okay right now with the prices going insane and, wages not, then I don't want you buying a membership. I don't want you super chatting. I don't want you any of those things. When I get people who, so a bit ago on the Patreon, like somebody was like, unsubscribe on the Patreon. And the thing is like, they put as their reason for unsubscribing is like, I am having financial trouble. And I'm like, fuck yes. If you are like having financial trouble, this is not like a necessity. This is like, this is luxury spending. And if you're not in a place to, waste money on fun shit, like, super chats and so forth, then don't. Cause, it sucks, right? And, the world is tough. And, there are people who are like, there's one person who canceled their subscription at one point because they're like, I lost my job. And then they restarted it and they were like, I got my job back. And I was like, yes. But, only do anything if you, if you're in a good place for it. So, yeah. All right. Wednesday says, thank you, Runkle. I feel guilt every stream, especially the fundraisers. Again, only give if you can. If you can't, you're still welcome. And, that is why, like, I won't do a stream like this as a members only, because I want everybody who cannot donate to still be here and to still feel like, you're an important part of the community because you are. And yeah. Crazy Cat Queen, you're breaking my rules here. Love you, Runkle. I decided to start selling my body plasma lol last week to make some extra money to pay for electricity and trash. Thank goodness we have our own well water. Don't super chat if you're selling plasma. I don't know how to explain this other than just don't. Like, yeah. So Petty sued for speaking out video demonstrated actual malice. So, right, we covered that. He published these February 2026 statements with actual knowledge of the falsity of his defamatory statements. Petty further demonstrated actual malice in that he possessed the June 25 to 27, 2025 text message exchange, wherein he admitted that Masika's patent application properly cited prior art that Petty said was hidden, and that Masika in fact filed his application before public disclosure. Okay, those could be real issues, right? That could be real issues. So that could possibly get to actual malice if he admitted knowledge before he published it. Petty compounded actual malice while inciting others to attack Masika, including when Petty explicitly instructed his viewers to amplify the attack on Masika at about 7:56 through about 8:22. Let's all talk about it as a community. Let's have a discussion. Share this video. Yes, but talk about it. If you're on Facebook, make a Facebook post. If you're in a community somewhere, make a post. If you have a blog, write a blog about this. If you're a vlogger, make a vlog about this. I guess we are. Make a podcast about this. Here we are. Discuss this with your friends. Discuss this with fellow magicians. I mean, you're allowed to tell people that, stuff is, stuff is important. Right? Like, yeah. Yeah, Elizabeth, I will never, like, if you show up at the meetup, and you're in Runkle like garb, I'll be like, cool. But if you are not in Runkle garb, I'm not going to be like, hey, what the fuck? That would just be ridiculous. Because you know who's not going to be wearing Runkle merch to the meetup? Runkle is not going to be wearing Runkle merch to the meetup. So, but the thing is this also isn't telling people to attack Masika. It's intending people, like it's saying, discuss. Talk about this. Boo, you should 100% wear Pigeon Business merch. I don't actually have any Pigeon Business merch, and I should. Although I just bought a shirt that's somebody else. Somebody else's merch. And it says out of spells, but not out of shells, and it has a wizard with a gun. I just bought one of those, and I'm like, that is awesome. I'm going to wear that to a D&D game. If it shows up in time, and if I decide to go to the thing, then I will totally do that. Wear one of your pins. That's not a bad idea. So, yeah. All right. Defendants continue an ongoing malicious campaign to destroy plaintiff's reputation, exhorting others to spread the false statements across the internet and elsewhere. The comments on the February 13th, 2026 video demonstrate that the defendants are inflicting direct, continued commercial damage with all these videos. Commentators have stated, I threw out my Yigal Masika stuff. That's not commercial damage. Because if you throw out all of your Runkle merch, Runkle loses $0. In fact, if you buy Runkle merch for the purpose of burning it in your backyard, I make money. So, yeah. Are the pins back in stock? I got to actually put the pins up for sale. So, yeah. They say, I will personally not buy any of his products anymore. Imagine if the entire community stopped buying his stuff. The thing is that more people are going to stop buying your shit because of this lawsuit. Like, suing for defamation is almost always the wrong move. And the reason why it's almost always the wrong move is because it is almost impossible to win a defamation suit and end up in a better place than where you were in the start. And the reason why I say that is, like, let's imagine you're a lawyer and somebody is like, Runkle is a shitty lawyer. And I'm like, okay, that's an opinion. I can't sue over that. And they say, Runkle is an unethical lawyer. And I'm like, that's still into opinion. I can't sue over that. And then they say something like, Runkle committed perjury in this specific instance. And I'm like, all right, now we're into a statement that could be defamatory. That is a statement of fact about a specific thing. Cool. And then I go, I would be fucking crazy to run a trial over this, because if I lose that trial, then I end up with a court verdict saying that happened. And I don't want that. Or let's imagine, you know, like somebody says you stomp kittens. Okay, so you run the case and 1 million people hear like stomp kittens with your name. And at the end of the day, they're like, they just associate like this person stomps kittens. Really hard to end up winning. In order to win a defamation case, you need it to be so ridiculously clear that you can dunk on this person. So, for instance, the Depp trial, you need it to be real clear. The TikTok psychic, real clear. But most defamation suits make life worse for the person who brings it, even if they win. Because the thing is there are assholes like myself. And I get to read this case. And I get to note that it's allegations. But now every allegation is getting read in public. Again, to an entirely new audience. And, you know, now all of these allegations are getting repeated, right? I don't drink, but I want to buy JD's rum because of the bottle. I kind of want to try JD's rum. I wish I'd found Runkle's channel earlier. Hopefully I'll be able to go back and watch some of the previous streams, especially the Depp trial. All of my Depp streams are still online. I will warn you, I come into the Depp trial midway. And the reason why I come into the Depp trial midway is that when Johnny Depp sued, I was like, Johnny Depp is going to lose. There is no way for a public figure like him to win a case like this. Like, he's going to lose. And then the case started up and like all of LawTube was like, we're going to cover this shit. And I was like, really? The only reason y'all are covering this is because it's Johnny Depp and because, you know, it's a famous dude. And I don't really cover stuff just because it's a famous person. I cover stuff because it interests me. And so I went on with Legal Bites. And I went on with Legal Bites because I like hanging out with Legal Bites. And I like hanging out with Rick Hogue. And like, you know, so I was just... And so because I was on with people I was, you know, friends with, I was like, holy shit. He actually has a case. He could win this shit. Like, he could actually win this shit. And then there was a moment when I realized that I had a shooting competition scheduled to take place in West Virginia. And I thought, how far away is West Virginia from Virginia? It really cannot be that far. And it turned out that my flight to get to the shooting competition was in Virginia. And then I like drove out of Virginia into West Virginia, shot the shooting. So I extended my stay because I was like, look, I know how I feel about the trial so far, but I don't know how the jurors are feeling. And so I wanted to see what the jurors were doing, because sometimes you like see the jurors and you see what their reaction is. And so that's how I got into doing the Depp trial. But like the Depp trial coverage on my channel starts midway, because for a long time I thought it would be fucking uninteresting. Like I just thought it would be boring, legally. Like straight up, I just thought it would be legally boring. You know, I thought it was just like Depp is running a vanity lawsuit. He's going to lose, and, you know, sucks to be him. So, yeah. Oh, yes, the Rob story. So you may notice that the tie is not where it normally is. And the reason why is because I packed the tie to come with me. But what is it? The Rob story is... So at this point, Rob, like... yeah, I was actually in the court. You can see me in some of the pictures. So the Rob story is that Rob found out that I was going to be in Virginia for some of the trial. And Rob was doing some coverage and, you know, so forth. And so Rob and I were technically like competitors, which isn't really a thing here, but, you know. And so Rob found out I was going to be there, and he reached out and he was like, hey, where are you staying? And I'm like, well, I don't really have a hotel, but I was planning on just showing up and going to different hotels and seeing which one has the best Wi-Fi and like staying there. And he's like, or you could stay with me. And I was like, seriously? And he's like, you could stay with me. And I was like, okay. And then I'm like concerned, because I'm like, is he gonna like murder me with an axe or something? Because, you know, you're going to a place where you just don't. And Rob is one of the nicest human beings you will ever meet in your life. Rob, like, I show up and Rob is like, do you want a beer? And I'm like, I'm a little tired. He's like, this is my homemade beer. And I was like, well, then I'm going to say yes, because, you know, you never say no to somebody's homemade beer. And it was fantastic. And he's like, I got you a little space to stay. I got you a, you know, I got you all of this. I got you all of that. And, you know, I was like, holy shit. Rob would like drop me off at the courthouse at like 3 a.m. And there were days when Rob could not give me a lift. And you know what he did? You know what Rob did? He's like, take my car to go to court. You drive my car. This guy who like I had not known at all, I'm like meeting this guy for the first time. He's like, take my car. As generous, as kind a person as you will ever meet in your life. So yeah, he's just amazing. Yeah. So, all right. So people in the comments saying the entire community needs to boycott Masika. I'll never buy his products. Well, maybe you should sue that dude, right? Maybe you should like, yeah. No more items for me, and other calls for boycott and commercial harm. Again, those calls for boycott and commercial harm come from the community, not from Petty. How many days do you attend the JD trial? I think it's probably like 14 days. I'm not sure. So yeah. So crowdsourcing information for the Masika versus Craig Petty slap suit. This video demonstrates ongoing malice by Craig Petty. After being served with a 105-page complaint detailing the falsity of his statements and the economic damages statements caused, Petty, misspelled, continues to produce videos mocking the legal process, disparaging plaintiffs' motives as a game to burn money, and actively recruiting the magic community to participate in his harassment campaign. It's not a fucking harassment campaign. He is like, he's expressing opinions. Despite having the published patent application in hand, which he claimed in his video to have already reviewed, which he admitted cited the relevant prior art, despite having the falsity of his statements demonstrated in the First Amendment complaint, Petty continued to defame plaintiff's character, portraying Masika as a bully abusing the legal system, protected opinion, seeking to bankrupt his critics, protected opinion, rather than the truth that the plaintiffs are legitimately protecting their intellectual property and business interests over the years. The thing is that this claim is like such a, I don't know. This claim seems so weak. Petty did not merely wrongfully claim that Masika was threatening litigation over his pending patent application, but falsely claimed that Masika had been falsely terrorizing others with lawsuits for 3 decades, with knowledge that Masika's patents were not valid. Am I taking crazy pills, or is this litigation? Like, this feels like litigation. And, it's like, we didn't threaten litigation, and yet you're in litigation. So is the thing that you just say you didn't threaten? Okay. The parties in Penguin's commercial marketplace. Plaintiff Masika Magic is a California magic product company founded by plaintiff Yigal Masika, an inventor internationally known for innovations such as loops, the tarantula device, and other proprietary magic apparatus. Petty is a magician, entertaining and teaching while selling products in the magic industry. Petty announces commercial activities in the magic industry in cooperation with Penguin Magic. Penguin Magic is a commercial online retailer that sells magic products, operates retail channels, produces monetized social media content, produces online videos promoting magic products, and has introduced house brand products, including ties that directly compete with plaintiffs' products. So, Rule 12b-6, a claim survives dismissal when it alleges sufficient factual matter accepted as true to state a plausible claim for relief. That is a bad way to put that. So the way this works is basically that, what do you call it? How do I put this? The in a claim, the claims that are well pled, which means properly pled, are taken as if they are true. And the reason why is because at this point they haven't had the opportunity to prove it, right? So they don't have the chance to show that things are true, and so the court will accept them as true so long as they are at least remotely plausible. And what I mean by remotely plausible is, like, if you plead that aliens, ate your baby or whatever, the court is going to be like, no, that is not something we are prepared to accept as true, because obviously they didn't, right? But if you plead something that is plausible, like, Bob punched me in the face, then, at that point, they will be like, okay, that is that is well pled, and, we accept that as true. And the courts will not reject that, even if, like, you plead, I didn't punch him in the face. They're like, yeah, okay, we have your denial, but your denial does not mean that we, that we accept that. So, cool, right? Tough shit. So, yeah, I get their point about, like, this stuff has to be taken as true, but that doesn't mean that, all of that. So, yeah. All right. Carrying on here. So, yeah, the way they should have phrased this is, a claim survives dismissal when it alleges sufficient facts that, if accepted to true, would state a plausible claim. Something, I don't know. So anti-slap, although the court already knows what the standard is, so they're just repeating it. Yeah. So anti-slap under federal procedure. California's anti-slap statute applies in federal court only to the extent it does not conflict with the rules. So courts may not require plaintiffs to provide summary judgment type evidence without discovery. Determining the internal scope of Eric Tate's employment with Penguin Magic, the exact contractual relationship with Craig Petty, and Penguin Magic's internal monetization and algorithmic online marketplace suppression metrics. I'm like, I don't even know what that means. Internal monetization and algorithmic online marketplace suppression metrics? That is some word fucking salad, and I'm going to order the steak. Give me the word steak. So requires discovery that plaintiffs cannot obtain yet, but would be in the hands of defendants. So the anti-slap motion must be denied. So the first thing they're alleging is a commercial speech exception. So California exempts any claim arising from 1, a statement by a person primarily engaged in selling goods or services. 2, about a business competitor's goods or services. 3, made for the purpose of promoting or securing sales. Or 4, made in the course of delivering the person's goods or services. And to me, I don't know that this really applies because, yes, they sell goods and services, but I don't think that was specifically a marketing video. That was an opinion video. So, but they say that all the tests are met because 1, Penguin operates an online retail marketplace. Lots of people do. 2, plaintiffs sell competing Magic products. Okay. 3, the challenge videos and posts disparage plaintiffs' inventions and professional reputation. And 4, the videos promoted Penguin's competing products, including ties, with embedded product links and monetized content. Now, what those exceptions are intended to cover is stuff like, buy my laundry detergent. It is way better than competing laundry detergent. Competing laundry detergent, if you're going to use that, you might as well just rub poop on your clothes because, who cares? You see how they want to, cover that, right? 9 out of 10, doctors prefer our product to competing product. They're like, we want to exempt that kind of thing. All right. So Penguin Magic is a direct commercial competitor, and Petty is aligned in business with Penguin Magic. The videos were not public interest journalism. They were monetized commercial content wrapped in Penguin Magic's branding, designed to disparage plaintiffs' competing Loops products and drive sales to Penguin Magic's house-branded Ties products via embedded commercial links. This statutory exemption alone mandates denial of the anti-slap motion. So here's the thing. I don't think this is an awful argument. I would make this argument as well. I would. I think it's a good enough argument that I'd run it. I would 100% I'd run it. Right? But that doesn't mean that I think it's the greatest argument I've ever seen. Right? It's like, okay, I get it. I don't hate the argument, but at the end of the day, I don't love it either. So, we'll see. It might prevail. And if it prevails, great for them. But if not, then, yeah. All right. So the motion conflicts with federal procedure. Under Metabolife and Planned Parenthood, the court may not impose a summary judgment evidentiary burden where discovery has not occurred. This independently requires denial. Guys, we're not going to argue Planned Parenthood because it is completely irrelevant here. And I don't want to have that debate right now. So moving on. All right. So even if anti-slap applied, Petty fails prong 1. So prong one requires Petty to show that the claims arise from protected activity. California Court of Appeal instructed courts to examine the principal thrust or gravamen of the claim. Lawyers, unless you're quoting a decision, or unless you really, really need to, please don't say thrust. Nobody needs your thrust. Okay, like maybe your partner does, but otherwise nobody needs it. And yeah, okay. Like just think about the poor streamers who got to read your stuff. So so here the gravamen is commercial conduct, including marketplace manipulation, product copying, suppression of searches. How is it suppressing searches? Algorithmic steering. I feel like this needs some explanation, and I feel like we're not getting it. Misappropriation of data. What? Okay, now you're just fucking throwing words out. Like, and commercial exploitation of plaintiffs' likenesses. They're not exploiting your likenesses. They are making fun of you. There is a difference. Like, they are criticizing you. That, you know, if somebody says Runkle sucks, that doesn't mean that they're exploiting my commercial likeness. And it means they're, like, you know, criticizing me. Like, if you say, like, you know, if you start selling shirts that are like Runkle shirts or whatever with my face on it, then you'd be appropriating my likeness. But moreover, the challenge statements constitute commercial advertising and promotion, not political or public discourse. I don't really buy this either. Failing prong one under coastal abstract services. So they say, while the representations need not be made in a classic advertising campaign, but may consist instead of more informal types of promotion, the representations must be disseminated sufficiently to the relevant purchasing public to constitute advertising or promotion within that industry. I mean, he's expressing an opinion that is about his competitor. I wouldn't say it's advertising. So, yeah. Petty fails prong two. Plaintiffs easily show a probability of prevailing. I can't sell your face. I mean, who would you sell my face to? Like people who need other folks turned into stone? So plaintiff's SAC includes exhibits demonstrating Petty's direct role in publishing and monetizing the content, the falsity of statements, e.g. that plaintiffs filed fake patents and made fraudulent threats, evidence of malice, profit motive, disregard of contrary facts. Profit motive is not fucking malice, dudes. These are the kinds of mistakes non-lawyers make. And to see lawyers being like, it is malicious because they make money on it, I am like, nah, dude. Read you some case law. Disregard of contrary facts is not necessarily actual malice. Commercial harm, lost sale, lost distributors, suppressed listings. Okay, they've pled some of that, so okay. Copying of plaintiff's products, that's not part of your suit. And consumer conversion and boycotts fomented by Petty. So, okay. Petty's video features Craig Petty falsely claiming that Masika does not claim Rinky Dinky is part of a history of not crediting other creators, while Masika publicly credited the Rinky Dinky as prior art in his published patent application. Rinky fucking Dinky. Okay. Why do they call it that? Yeah. What is it? Have you seen Legal Bites' Chud case video? I have not. I question her explanation of how self-defense works, waiting to see your take, even if he's generally appalling as a human. You can see my take at the lovely occasion of last week, We covered that last week. So like last week. All right. Under Roberts versus McAfee, this showing of false statements above exceeds the potential merit standard and defeats prong 2. Further details regarding false statements are provided below. So Craig Petty is not an independent actor in the scheme to disparage Masika and divert sales to Penguin Magic's Ties products. A transcript of Craig Petty's own video, Penguin Magic at Blackpool 2026, from February 14th. He told the public, "Come over to the Penguin booth, see me and Eric." And Tate stated, "Yep, you and I are on the booth." Okay. Petty also publicly stated in his own video, so Petty established his roles as a company insider / agent by using the corporate "we" when stating there was no Penguin booth on Monday at all because we had nothing to sell. Tuesday, we're going into it with nothing either. Petty stated that in this July 22nd video that he was representing Penguin Magic. Specifically, from about 1945 through 2017, he stated, I'll be on the Penguin Magic booth, so I'm actually going to be there on behalf of Penguin Magic on the Penguin booth. Petty himself proves that he and Penguin Magic have a deeply integrated commercial partnership, not a mere vendor relationship. I have been asked to come up and be on other people's booths. Like, that is a thing. Also, yes, Runkle has no time to watch other people's vids. He has a stuck car, a family, a full-time law job, plus us. Yes. I am hoping to move to a kind of part-time law job. And when I say part-time, it'll be like day job, but part of the year. And if that happens, it will enable two things. It will enable, one, more Runkle live trial coverage, like covering trials as they happen. That will be a thing that we can do if that happens. The other thing it'll enable is more Runkle pro bono work, where I can just do law because people need it. And so that is the hope. I don't know if it'll materialize. I don't know if it'll happen, but I have hope. So the stack states that's the second amended complaint. Why they call it the SAC? Just okay. They're saving words here, but it's the SAC. I'm like, all right. We've talked about the SAC. We've talked about the thrust. We talked about the. That's where we're at. So defamation, trade libel, and false light. So A, public figure issue. Petty argues that because plaintiffs pleaded having developed a fine reputation and thrust themselves into industry disputes, such as sending cease and desist letters, Masika is at least a limited purpose public figure. Petty states that should be enough. However, that is not enough, especially as Petty does not commit to what type of public figure is Yigal Masika. Man, the grammar in that sentence is like, what? Okay. So, public figures in the context of those needing to prove actual malice defamation may be public officials, general purpose public figures, or a limited purpose public figure. A public official, for example, California Governor Gavin Newsom, may still validly allege actual malice. Yigal Masika is a private individual, well known in the niche magic industry, but not a general purpose public figure, nor even a limited purpose public figure in relation to the allegations by defendants that Mr. Masika must show actual malice in relation to a matter of public interest. I mean, could you not be a limited purpose public figure in the specific field that you indicate you are well known in? Like, if you are well known in a specific, industry, that being the magic industry, then you might be a limited purpose public figure for the purpose of the magic industry. I don't like their argument because it's just not addressing what I think needs to be addressed here. And I'm like, you feel like you're hiding the ball. You feel like the magicians are not the only people doing a little bit of legerdemain and, you know, misdirection. Like, look at this hand and don't pay attention to what this hand is doing, right? So, yeah. Some individuals occupy a position of such persuasive power and influence that they are deemed public figures for all purposes. Who the fuck cares about this argument? I don't think that Petty is arguing that Masika is like Johnny Depp or Trump or, you know, whoever. He's arguing. So, like, you're saying, okay, he's not a general purpose public figure. No shit, right? But I don't think anybody was actually arguing that at all. And so if nobody's actually arguing that point, then why y'all making an issue of it? Like, I just don't I do not get it. So okay. All right. You know, it's like asking your kid, like, you know, you ask a kid, did you, you know, steal the cookies out of the cookie jar? And the kid's like, I walked the dog. You're like, okay, interesting answer. But I asked you about the cookie jar. And they're like, walk dog, though. It's like, well, the worst thing you could do right now is write me a letter about how you walk the dog. But, you know, it's not helping my, you know, my issue here. So this category is designated as an all-purpose public figure. An all-purpose public figure is not lightly assumed. For a plaintiff to be deemed an all-purpose public figure, they must be clear evidence of general fame or notoriety in the community and pervasive involvement in the affairs of society. Again, nobody... The Supreme Court distinguished the Gertz opinion, stating, here we hold that, at least where a newspaper published speech of public concern, a private figure plaintiff cannot recover damages without also showing the statements at issue are false. So when you see somebody responding to your filing, and one of the things that they do in response is they start responding to arguments you never made, and like they start doing that kind of shit. You know what I start doing? I start checking citations. And the reason why I start checking citations, come on, camera. There we go. The reason why I start checking citations is that this is the kind of thing that makes me worry that somebody might be using AI. Sorry, folks, that little disappearing thing. Magic. Like, you know, if you are starting to answer questions the other side wasn't wasn't asking, it's like, is this some ChatGPT shit going on? I don't know if there is, but I would be checking the citations here if I was the other side. And yeah. So plaintiffs who make equipment for a niche market but do not advertise or sell to the general public were found not to be all-purpose public figures as they lacked pervasive involvement in the affairs of society. Wait, they don't advertise or sell to the general public? They have a webpage. Knife through arm. A professional illusion built to be believed. You press a knife through your forearm and it sticks out the other side. Okay. And then I can just add to cart. And then I can go to checkout. And check out. Let's see. It wants me to enter an email address. So we're putting in fuck@you.com. I don't see anything here requiring me to, like, you know, certify that I'm a real magician or any of that shit. So, like, when they say that they don't sell to the general public, I'm just going to say I'm a member of the general public, and you sell to me, so I would not put this in fucking writing here. Like, I would not put this down as a thing, because holy shit. Good night, Rob. Good to see you. Masika's reputation is tied to the commercial sale of his inventions within a niche community which does not amount to the general fame or notoriety required to strip plaintiffs of private figure protections. Okay, but talk about limited purpose. Nobody says you're a general, like, nobody says you're fucking Elvis, dude. Like, either meaning. The Supreme Court established the legal standard to define limited purpose public figures, yes, as those who have thrust themselves to the forefront of particular public controversies in order to influence the resolution of the issues involved. Plaintiffs did not interject themselves into any public controversy. Petty dragged them into public controversy he decided to manufacture. Except that this might be an issue where your cease and desists could get you into a, into trouble there. So, even if one considers Petty's issue to be a public issue, a private individual is not automatically transformed into a public figure just by becoming involved in or associated with a matter that attracts public attention. Thus, the defendants must show more than mere newsworthiness to justify application of the demanding burden of pleading the heightened actual malice standard. Masika sells on Amazon. Hard to say that's not to the public, right? I should start another goal, and the goal is going to be Runkle have that. So the goal will be Runkle Clamato already. I feel like we can set that as a goal. So enforcing intellectual property rights through private legal channels does not mean that plaintiffs voluntarily injected themselves into a public controversy. Petty publishing his defamatory video in July 14th, generating public attention, was not participating in a public controversy. He created a public controversy grounded on his intentionally false statements, such as saying that the Masika did not create prior art, despite his or did not cite prior art, despite his admission in the text messages that he knew Masika's published application referenced the specific prior art that he claimed in his video Masika intentionally did not disclose. Now, this is kind of a fair point, because you can say, like, one of the things you can't say is, because I made a controversy around Bob is now a public figure. Like, that's not how that works. Bob's got to do something. So Beth Aviv says, good afternoon from Japan. I want to visit Japan so bad. I've never been. And I really want to. The problem with me going to Japan, I'm going to tell you this. I cannot eat enough for what I would want to do in Japan. Because, like, I'm not I'm not one of the people who's like, hey, I totally, need to buy some anime. I totally, whatever. My, like, tie to Japan, my thing that it would be like, this is what I want to do, is I want to eat all the things. I want to go to a ramen shop that's, like, older than I am. I want to go to a sushi place where, like, the guy just, I want to go to a sushi place where, like, hell, I want to go try fugu. And if I die, cool. That like, put that on my headstone. Like, Runkle died doing what he loved, eating weird food. So I mean, like, I would just be going everywhere, like just trying to eat all of the things. And yeah. Tide is going to say that I cannot, that I'm not allowed to die, but like I want to go and try all the things, right? I just want to, there was a thing on Twitter where somebody was, so somebody on Twitter posted that they went to what they thought was a illegal, like an illegal ramen place, and that it was so spicy they nearly died. And I want to go there. I'm just like, I need to know where this place is. And so like, yeah, I just so much want to I so much want to go and just try all the things and do all the things. And yeah, I it's on my bucket list. So Mrs. Runkle's travel bucket list. She's got a couple of places on her travel bucket list. One of them was the Galapagos Islands, and I was lucky enough to be able to take Mrs. Runkle to the Galapagos Islands, and it was magical, like just straight up magical. The other one is Thailand. She wants to go to visit Thailand at some point, and I mean, I'm down, but I'm kind of nervous about visiting Thailand because, from what I understand, it's like a serious offense to make fun of the king of Thailand. And I have intrusive thoughts. So, like, I'm like, I have a nervousness. I've got concerns. Because, yeah. But my bucket list trips. Japan. And the other one is a survival tourism experience. And the survival tourism thing is they drop you off on an island, and you just you hang out on the island, and you kind of do the survivor shit. And yeah, I also want to see Australia, but I really want to do one of those things where I just hang out and go like forage and so forth. And yeah. And I want to do that before I get too old, because eventually I'm going to be old, and it's going to be, it's going to be a situation where like I can't do the shit that I need to do. So, Crazy Cat Queen, I'm really sorry to hear this one. My girlfriend and I were supposed to do a Galapagos cruise because it's on my bucket list too, but my bestie has kidney disease and her transplant started failing. I am really sorry. I just Galapagos was magical. Like just absolutely magical. And I got to swim with penguins. I mean, you're swimming and there's like penguins, just buzzing around. So yeah, slightly off topic, but have you ever tried any of those super spicy Korean nuclear ramens? Yes, I have. I think they taste like shit. They're spicy. I mean, they're not inedible spicy, but they're like really spicy. But they taste bad. And so I'd rather get regular like ramen and throw in hot sauce until it's like lethal than to do the those ones. So yeah. Oh, I haven't gotten through all the hot sauces. So yeah. What do you call it? All right. Petty knew that his statements in the Penguin Magic video and in the prior Craig Petty video were false or acted in reckless disregard to the truth. Okay, we're into the standards. The New York Times versus Sullivan standard does not require that the reporter hold a devout belief in the truth of the story being reported, only that he or she refrain from either reporting a story he or she knows to be false or acting in reckless disregard of the truth. But they still don't really properly address the standard to my feelings here. All right, public interest issue. Defendant's defamation was not a matter of journalistic reporting, as neither Eric Tate of Penguin Magic nor Petty have any journalism credentials. So, how many of you have ever seen the Trunk Monkey commercials? Like, I kind of want the existence of a legal trunk monkey. And what the legal trunk monkey would do is anytime a lawyer files something saying that somebody has no journalism credentials, that monkey would climb out of a vent and hit them with a pipe. Journalism credentials are not relevant here. It doesn't matter if you went to fucking journalism school. The First Amendment was not built for people who went to journalism school. It was built for some jackass who's standing on a soapbox. It was built for somebody who is printing pamphlets with woodcuts. It was for somebody who just like is shouting into the void. No, stop it. Stop it. The First Amendment does not require a certificate. You have the First Amendment by virtue of existing. Like, yeah. So instead, defendants conspired to make a coordinated, bad faith commercial attack to destroy plaintiff's reputation so that Penguin Magic and Petty could step into the void when Masika's sales are depleted and Penguin Magic can sell house brand knockoffs at the conventions and other events Eric Tate and Petty jointly operate. Petty holds himself out as a Penguin Magic insider/agent. Defendant Petty does not identify a valid matter of widespread public interest, but a matter of dispute between plaintiffs and defendants, and maybe Mark Bennett. The thing is a dispute that is within the field, like within a field, can be a matter of public interest. You know, just the fact that it is a subset of the public doesn't much matter. You know, interestingly enough, I do have a journalism degree. They told us 90% of the way through the course that none of us would get jobs. Yeah, that is a thing. Good morning from Sweden. Breakfast and a Runkle rant about the First Amendment is a good way to start the day. Cecilia, what does a Swedish breakfast look like? I am really curious. So they note the fact that a broad and amorphous public interest can be connected to a specific dispute is not enough. The defendants cannot merely offer a synecdoche theory of public interest, defining their narrow dispute by its slight reference to the broader public issue. In other words, defendants cannot expand the tree of their specific dispute with plaintiffs as a matter of public interest about the entire forest. All right. The statements are provably false. So they say the exhibits to the SAC provide tables referencing a portion of the false statements published by Craig Petty and Penguin Magic and republished by Penguin Magic. Petty made statements in his app or his video that Masika's published patent application numbers, that Masika stole the idea of the invention without crediting the creator of the Rinky Dinky device. God, I hate the rinky dinky device. What is it? Usually it's a small bowl of yogurt with muesli and cheese and a cucumber sandwich, at least for me. Not many Swedes go through the trouble of a hot breakfast. And I see smoked kippers and quail eggs with cheese. So in Norway, when I was in Norway, I mean, I usually had cereal or eggs and, no bacon because bacon was fucking expensive. But, I'd have eggs and, whatever. But what is it? I got invited for like a, hang out at people's house thing. And that included some, like staying over, and they made breakfast. And the breakfast was like pickled herring on, what do you call it? Like what's the word? Like flatbread with other stuff. And I was like, this is actually a really good breakfast, believe it or not. So I enjoyed it. I like the cold breakfast thing. So I have put some beer in this thing, and now we're having Clamato and beer. So this sounds right. Knockabrod, like flatbread. Did you get to try the caramel cheese? So I didn't have any brunost in Norway. And the reason why I didn't have any brunost in Norway is that my grandmother was Norwegian. And so she loved brunost. And she would take every opportunity to try to get me to eat brunost, including telling me, oh, that stuff you had the last time? No, this is a different cheese. It just looks the same. And I try it, and it's fucking brunost. I don't like brunost. It's not something I like. My grandmother was not a proponent of lutefisk, and so I have yet to try lutefisk. But I did have reindeer. One of my relatives in Norway took me out to a restaurant, and he was a former military guy. He's got decent money. And so he takes me out to this restaurant because, we're hanging out, we're meeting. And we've got the menu, and I see the menu, and one of the things on the menu is reindeer. And I'm like, I want to try the reindeer. And he was getting annoyed at me. And the reason why he was getting annoyed at me is that he wanted to buy me the steak. And the reason why he wanted to buy me the steak is because the steak was like 3 times the price of the reindeer. It's expensive. Beef is expensive in Norway. And so he was trying to show off that he's like financially stable by buying me the steak. And I had to actually explain to him, I was like, look, there is so much steak in Alberta, but there is no reindeer. And so I want to try the thing I cannot get in Alberta and not the thing that I can get lots of. And he finally was like, okay, I understand. And I'm like, thank you. Let me get the thing I wanted to try. Yeah, I tried a bunch of fun stuff in Norway, and it was, yeah. All right, back to the thing. My attention deficit. I am sorry, folks. I know I'm wandering all over the topics. My attention deficit is so chaotic today. I just, I'm all over the like, my brain is just everywhere today. But, yeah. I am looking forward so much to Chicago, not just for meeting all of you folks, because there's a bunch of people who are like, I'm going to be there, but also I'm going to try deep dish pizza. I'm going to try the Italian sandwich. I'm going to try all the things. You know what? I'll even try the Malort. I will even try the Malort. And oh yes, the Chicago dog. I got to try the Chicago hot dog. So, I mean, I'm going to try all the things, like all the things. And I am looking forward to that too. All right. As shown in paragraphs 6 and 7 of the published application in Exhibit A, Mesika's patent application publicly referenced the Ring Flight Revolution and the Rinky Dinky device in the section entitled Description of Related Art. It is without question that these two devices were volunteered to the Patent Office publicly in Mesika's patent application filed in June 13th and published on December 19th. The thing is okay, I can get that they can launch a defamation claim on this. What are your damages on this shit? What are your damages? Has Runkle eaten anything today? Runkle had a giant leftover burrito. So, yeah. Petty acknowledged as much in his text communications with Yigal Mesika in June 25 to 27. On June 26th, as shown in these text messages, Mesika acknowledged the existence of the Ring Flight device and told Petty that the version I developed isn't just another Ring Flight. It's a complete redesign with specific innovations that were recognized and protected under patent law after a long and detailed review process. Petty doesn't have to agree with Mesika, though. Like, yeah. Runkle, you have to film your... I hate that you're right, Celine, but you are right. So, I do have to film it. Further in this text message chain, Craig Petty confirmed on June 26, 2025, that I've looked at your patent application and I see the innovations you are referencing, especially in comparison to AirFlight. Petty confirmed that he saw in the published application that Mesika's application mentioned the prior art. Okay, but like the other shit is, yeah. Further, on June 26th, Mesika told Craig Petty that he'd been communicating with Mark Bennett and that everyone recognized the overlap and were working out an amicable path forward. No drama, no lawsuits, just professionals sorting out a similarity. Mesika further stated to Petty that also AirFlight is mentioned at my patent even before it exists. Yet further on June 26th, Mesika stated, I haven't threatened litigation. In response, Craig Petty stated, I know that your patent mentions an AirTag towards the end. He later stated in the same text message, I know you aren't threatening to sue Mark. Petty confirmed on June 27th that he understood that Mesika was not threatening litigation against Mark Bennett, contradicting his and Penguin Magic's later allegations that Mesika is a litigious bully and a patent terrorist or a magic terrorist. I mean, all of those things are not really actionable. Patent terrorist? Like, what does that fucking mean? Honk Banana Nose says, Runkle, if you promise to drink Malort in Chicago and live stream it, I'll buy a bottle and throw down a shot with you in solidarity. Word is bond. I can't promise that I'll live stream it. I might go live at the thing and do like a Malort thing or whatever. Go live for 15 minutes or whatever. But I can't promise to live stream it because I might be in a position where I videotape it and then so yeah, I might videotape it and upload it later. Or I might videotape it and use it as like a clip or a maybe I'll use it as a what do you call it? Maybe I'll use it as a goal, like a stream goal. So yeah, we'll see. Or yes, I got to do shorts for Rumble, so that's all a good idea. So despite this clear acknowledgement that Mesika did not steal his invention, did not hide the prior art such as AirFlight and Rinky Dinky, and that Mesika was not threatening litigation, on July 14th, Petty made knowingly false statements contrary to his knowledge, and he repeated those false statements in Penguin Magic's July 25th video, republishing and ratifying those false statements. And at the end of the day, I don't think he's going to get enough money from, from that to do it. Honk Banana, no. Wait. Like, I don't know if the Green Door Tavern has Malort, right? But if they do, I will try some Malort. If they've got it. God, I'm going to regret that. It is without question that Craig Petty made these statements. The statements were false, and plaintiffs have a high likelihood of prevailing and proving the falsity of these statements. The false statements do not stop there. Petty republished false statements from third parties. Petty himself stated that Mesika is a patent troll. What is patent troll? Does it have a firm definition? And takes intellectual property by stealing it. They're claiming it's theirs, and then they go after any possible entity that might have something to do with the knowledge that's inside that pack. Petty knew from the text message conversation, as he conceded, that Mesika was not threatening litigation. Petty states that Mesika was Magic's biggest litigious bully for the last 3 decades has been financially and legally bullying creators into submission behind closed doors. Petty represented to the public that he was bringing facts, not merely opinions. So at 3:55, Petty claimed that Mesika is now trying to sue anyone who brings out their own ring flights, and that Mesika never will have a patent approved. He knew for a fact that Mesika was not trying to sue Mark Bennett. At 4:50, Petty states that Mesika's invention was stolen in the first place, and that he was bullying people. He knew that Mesika was not bullying Mark Bennett, and that he had no other knowledge of any other alleged bullying of any other person. The thing is that this is going to be one of the most entertaining trials for the jury of all time. Runkle, are you going to see Mike while you're in Chicago? He's coming to the meetup, I think. So I believe he'll be there at the meetup. So I'll see Mike, and you might see Mike if you're there. So at 5:40, Petty maintains that he consulted with a lawyer before recording the video, which, if true, shows that he followed Mesika's admonition to seek legal counsel before making his claims publicly. This statement, if true, shows that Petty had doubts, but proceeded recklessly or with full knowledge that his statements would be defamatory, further showing actual malice. Fuck you, lawyer who wrote this. Going to a lawyer and saying, I want to make sure I'm in compliance, is not at all evidence of actual malice. Right? Like, it's not actual malice to hire a lawyer to be in compliance. Are you fucking kidding me? Indeed, he states in 6:53 that he deliberated over 2 weeks before completing the video. Okay. Petty states that Mesika's ring flight came out in 2025. Again, that doesn't get me to actual malice. That gets me to he thought about it. So, Petty states that Ring Flight came out in 2025, while he was told in June 26th in their text message conversation that Mesika publicly released his project around February 2024. Okay, not every error that you make in a public statement is defamatory. Mesika's patent application filed on June 13th, 2024, and published on December 19th, 2024, claiming priority from a June 13th provisional patent application. It is noted that when Petty's motion claims that Mesika apparently released his device several months before filing his patent application, Petty makes no reference to the filing date of the published application, nor his concession in June 2025 to Mesika's representation that his application filed before Mesika released his device. Didn't you just say in their text message conversation that Mesika, he was told that Mesika publicly released his product around February 2024? Mesika's patent application filed on June 13th, 2024 and published on June 19th. I am fucking crazy. Like, I am... Is February 2024 not before June 2024. Like, am I taking crazy pills here? Julia, do not send me home with Malort, because the Matas are sending me home with a bottle of booze, and I can't bring 2 bottles, or else I have to pay duties, and the duties are insane. So, like, February is before June, right? Like, it is noted that when Petty's motion claims that Masika apparently released his device several months before filing his patent application, Petty makes no... Oh, claiming priority from a June 13th, 2023. Okay. That's a bad place to drop a character. All right. They're like, we filed early. Okay, fair. Fix that. Fix that. Because, like, I don't know. Maybe I've had too many drinks, but that that made no... Yeah. Yeah, 200 or 203 is way before 2024. You're not wrong. All right. Petty makes no reference to the filing date of the published application, nor his concession in June 2025 to Masika's representation that his application filed before Masika released his device. Okay. The typo I get. Petty could have and should have reviewed his text messages, the published application, and the SAC before he made again this false statement. If Petty had reviewed Exhibit B to the SAC, he would have understood that his statement repeating this lie was false, as explained in the parenthetical statement. If he had reviewed it, you need to show that he did. Because, like, simply not reading something does not get you to actual malice. So, at 1:45:57, Petty again makes this false statement, stating that Yigal Masika's product was released months before the patent was actually filed. It also, like, him not understanding the issue is also not actual malice. The green door has a shot wheel. Oh shit, I gotta do that, don't I? So Petty stated regarding Masika's applications, most of them aren't granted, most of them are never granted. So Petty's Exhibit D claims to be a quick patent search, so shows 13 issued patents. This evidence alone represents the falsity of Petty's statement. In fact, Masika has more than 15 issued patents. Okay, but how many were not issued? Yeah. Oh, hey, Nick Starro. Thank you for the gifted memberships. Thank you. Good to see you. So at 118, Petty maintains again that a lot of the patents that Yigal put through never get granted. So the reckless nature of Petty's tirade shows that he accuses Masika of using his superior power to get patents to bully others, but he's incompetent at obtaining patents to perform that bullying. I feel like this should be just a response video, right? I feel like this should be I feel like this should have just been like Yigal Masika putting out a statement, dunking on the, like, filing a defamation lawsuit is it is almost always the wrong approach, right? Almost always. So Petty falsely states that Masika had dozens of patent applications, few granted, when his own exhibit shows a maximum of 32 patent documents, some being merely the published application before issue of the same invention. At 139, Petty refers to Masika's invention, talking directly towards Masika as if he was present. You didn't even credit the person that most people would consider to be the godfather when it came to ring flights. On June 9th, Masika, through his patent counsel, filed an information disclosure statement disclosing to the United States Patent and Trademark Office an Al-Quran ring flight document from 1968, a Sumag magic ring flight document from 1967, and an Al-Quran rinky-dinky document from 1967. Why do you keep going back? Like, make your point about the rinky dinky and move on. The fact that they keep hammering this is bizarre. Are the goals broken? They are broken. YouTube is broken for some reason. And yeah. The Rinky Dinky Document is a great name. The Rinky Dinky Document is a terrible band name. So, yeah. What is it? Woo! Thank you for giving me the membership. I'm a big fan of Ian. My firearms instructor went hunting with him once. I have narrowed down who your firearms instructor is to one of two people. It was either David or Adriel. And yeah. In the June 25th Penguin Magic video, Craig Petty made additional false defamatory statements. He stated that regarding Mark Bennett, legal action was threatened. As shown above in reference to the Masika Declaration and the text message conversation, this statement was false, and Petty knew that it was false. Petty continues his reckless disregard by claiming that Masika gets patents issued to bully others, but hardly any of them get granted. You already said this. Again, this kind of feels like AI in the way it just keeps looping. But I mean, I don't know. And the ones that do get granted, he just allows them to expire. I mean, that is what patents do. Petty repeats his other false statement, claiming that Masika's invention was commercially advertised on the Magic Cafe up to a year and a half before the patent was even filed. Cthulhu Unthor says, hey, I just woke up and this is crazy, but here's my money, so hot sauce maybe. I can do a hot sauce. Where'd I put the hot sauces? Here they go. And this one is simple hot sauce. All right. Cheers. Oh, that's just like a vinegar. Oh, it's got a sweetness to it. It's kind of in the same vein as Frank's, but it's better than Frank's. So, all right. Petty makes the audience believe that he's speaking from knowledge gained from reviewing documents when he states that Masika has a documented history over the last 20 years of using fake patents and patent applications and legally bullying and intimidating people to try and force his will onto them. Petty has not reviewed 20 years of documents that support his false statements, and he wanted his audience to believe he gained such knowledge from reviewing a documented history. The reason why they're saying that is because a statement of opinion can become defamatory if you imply that it is from concealed facts, if that makes sense. So, Runkle Chicago meetup, May 30th, 6 p.m. at the Green Door Tavern. What is the hot sauce lore? Oh, we just taste them. I am a hot sauce fiend. I love hot sauce. So yeah. Petty states that the Masika, why do they keep calling him the Masika, is the most litigious person in Magic who's got a habit of habitually suing people, as shown in Exhibit N, in reference to Petty's claim that Masika is the biggest litigious bully for the last 3 decades. The last column of the table provides a lengthy list of lawsuits in the Magic industry. Masika has not achieved the distinction of being the most litigious person in Magic, let alone for 3 decades. You know how you convince everybody that you are not litigious? You file a fucking lawsuit. Like, you gotta be kidding me. This makes no sense to me as a strategy there. Statements concerning Masika Magic. So defendants might have thought that their disparagement actions and anti-competitive conduct only affected Yigal Masika, but they also damaged Masika Magic, a corporation. Plaintiffs seek damages from the defendants for all damages attributable to their torts. Torts is just legal wrongs, right? Opinion can be actionable. The Newsom versus Fox News opinion, which explicitly applies California law, held that statements of opinion on matters of public concern are not categorically shielded from actionability. Instead, an opinion constitutes actionable defamation if it can be reasonably interpreted as stating or implying defamatory facts about an individual that are provably false. Prefacing a statement with, in my opinion, does not provide immunity. So they give the example of, in my opinion, John Jones is a liar, implies a knowledge of facts which lead to the conclusion that Jones told an untruth. When a speaker discloses the facts underlying their opinion, they can still be held liable if the disclosed facts themselves are false and defamatory. So malice is adequately alleged. Recklessness or doubt, which gives rise to actual or constitutional malice, is a subjective test. This may be demonstrated through circumstantial evidence, including a failure to investigate, anger and hostility toward the plaintiff, or reliance on unreliable sources. So here, the minimal merit standard is easily satisfied as to defendant's malice, as plaintiff has alleged and proved or provided significant evidence of the failure to investigate, reliance on biased and unreliable sources. Who was that? This is new. And hostility towards plaintiff and their intellectual property rights. Actual malice does not require that the reporter hold a devout belief in the truth of the story being reported, only that he or she refrain from either reporting a story he or she knows to be false or acting in reckless disregard of the truth. You've quoted that already. Why are we doing that again? Defendants argue that at most, plaintiffs have only alleged that defendants must personally investigate the falsity or reckless disregard of their statements, which defendants claim does not equate to actual malice under standard. While a mere failure to investigate is not enough, a speaker cannot purposely avoid the truth and then claim ignorance. If a plaintiff offers direct evidence that the statement was provably false, the court may infer that the defendant intended to avoid the truth. Defendant's own cited case, Saint Amant, helps show how to establish actual malice. I think that the plaintiff here might overcome the dismissal here. However, I don't think it's a good idea. And I think that there is there's a reasonable possibility that this lawsuit turns into an absolute clusterfuck for them. And I mean, you've got to be like, for any lawsuit, you've got to ask yourself the important question of what happens if I win, right? Like, is this going to get me a good result? Because if you file a lawsuit and you win and the and the result is bad, why would you do that thing? Right? Like, why would you bring a lawsuit where your best case scenario is still a bad one? And why would you bring a lawsuit where your worst case scenario might be even worse? Defamation cases usually live in that space. So defendants did not merely fail to investigate, but they purposefully avoided the truth by publishing statements that Masika hid prior art while willfully ignoring the publicly available patent application that explicitly disclosed the Ring Flight Revolution, Rinky Dinky, and AirTag device. I'm also just going to note, like, look at the Afroman trial. Do you think that any of those plaintiffs feel real good about having brought that case? Do you think that any of them feel like they came out ahead? Because I don't. I don't. The Superior Court of Delaware applied substantive California defamation law and to recognize that actual malice can be proven through an accumulation of circumstantial factors, specifically including financial motive and a preconceived false narrative. The Delaware court evaluated the complaint under Delaware's highly permissive conceivability standard, while in the instant federal litigation, the stricter plausibility standard applies under Twombly and Iqbal. Plaintiffs submit that the detailed exhibits and factual allegations meet the federal plausibility standard. So, misappropriation of likeness. Petty used plaintiff's likeness in monetized videos and product promotion. This is commercial misappropriation, not news. I wouldn't even file that claim, but yeah. Unfair competition and false advertising. The SAC alleges counts 8 to 10 against Penguin Magic, but not Craig Petty. So they want to deny the motion to dismiss, deny the motion to strike, permit discovery to proceed, award attorney's fees, and grant leave to amend if necessary. Okay. So that's where the lawsuit between the magicians stands now. I mean, they may overcome the motion to dismiss, which is tough on a defamation suit. They still should ask, do we want to do this? Like, is this actually going to build our reputation, or is this just making it worse? Like, if you're worried that people are saying you're litigious, suing is the worst way to disprove litigiousness that you can possibly get, right? Like, just it's a thing. Now, I have some other stuff I could cover, including a couple of lawyers getting shot. But we're going to cover that next week. I'm going to save it. Remind me to cover the lawyers getting shot. But anybody watching chat wondering, should I go? I won't know people. It'll be awkward. If you can do it financially, please come join us. Please, I want you to go. If nothing else, you've got like something to talk about. Michigan Farm Boy, they're continually misstating the claim. Perry said they didn't acknowledge the creator, not that they didn't acknowledge the Rinky Dinky, if I remember correctly. Yeah, that could also be a big problem. So somebody's saying, did they survive? I'm just trying to see here. Did they survive? So the two attorneys have non-life-threatening injuries. They're both going to live. So, yeah, the lawyers are fine. We'll cover that next week. It'll be a little stale, but it'll still be interesting. I am getting tired. I did not sleep well last night, and the reason why I didn't sleep well last night is that Zora, during the night, got the idea that it was time for her to get dinner. And she got that idea that it was time for her to get dinner at about 3 a.m. And 3 a.m. is not when Zoras eat. And so she woke me up. She was being a bit of a jerk. And yeah. All right, let's cover super chats. Misbehavin says yes to spicy. Thank you. Lynn M says, looking forward to Saturday if I don't chicken out about the drive. I hope you don't. It'd be great to meet you. Fiona W says 3 years of awesomeness. Thank you for being you. Thank you for being here too. I'm glad to have you. Mildred Katie tried a predecessor of Malort at an SCA event. It's a Polish cordial named Pietonuka. I might be mangling that. Main difference is that it's sweetened. Huh, interesting. Skisi says, lol, was enjoying the not a goat search game. Fair. Runkleism, that's not a goat, that's ammunition. Hello, it's Britt. Thank you for the super sticker. Much appreciated. Meme Empress, Runkle, we don't need or want the details. Fair. His new nickname is Mr. Hands. Oh, that's awful. Ryan Gallo, looking forward to the meetup in Chicago. It's all about supporting your nonprofit law goals. I will feel very bad if I'm the only person there at the meetup for two reasons. One, I will feel bad if nobody shows up. Two, the bar has a $1,500 minimum spend. And so if nobody shows up, I owe the bar $1,500 US. But if people show up and drink, that deducts from that. So I'm hoping there's going to be a whole bunch of people having food, having drinks, just having a good time, and that I don't end up owing the bar $1,500 because, whew. So yeah. 3 a.m. is not when anyone eats unless you're doing the old Afro-Man special or working graveyard, I guess. You're not wrong. So, yeah. What is it? No, that was not a question to me. So, Your Honor, we seek a judgment since the defendant isn't really magical. For our first exhibit, we'd like to introduce the Malleus Maleficarum. No, but this could actually be a really interesting trial because you'll have magicians who will be there doing magic. Because they're going to have to demonstrate some of this stuff, right? I feel like they're going to do some demonstrations and so forth. And so that will be a pretty cool thing for the jury. So, Asher Graves says, that feels like an expensive minimum spend. It's not that bad overall. It actually goes a lot faster than you think if people show up and if people, have food and drinks and so forth and all of that. So, yeah. I went to culinary school to cook for hubby. I kind of would love to go to a culinary school at some point. FEZ says, thank you for the 5 gifted memberships. I like the pixelated, icon there. Country Girl, love your take on things. Refreshing. Southeast Alberta. Thank you so much. Kimchi, the forensic homeopath. How much can I give you for your ratatouille recipe before November? I will send it to you if you can't find it. I have a family full of dietary restrictions and severe food allergies, and I'm running low on stuff that works for everyone. I really like this recipe. Dog Mom, thank you so much for the gifted memberships. Michigan Farm Boy, Streisand effect is a real issue for most of these cases. It really is. Ian BPPK, your it's important you say yes moment, basically. Kind of. Meme Empress, comes now, thrusting. Ian BPPK, I think it may be referring to things like SEO. Yeah, I just don't see how it's relevant to the lawsuit. Comes now, thrusting the sack. Meme Empress, you are a bad person. ASG says, hey, Runkle, I'm so proud of myself. Up to 140 words per minute in my court reporter schoolwork. I'm almost halfway there. Wild stream tonight. That is amazing. And I know you'll get there. Stan with Mel says, regarding mental illness certifications, if USA had that, we would have had a lot of celebrities picked up. I mean, if you heard some of the crazy shit Tom Cruise has said about aliens, etc., lol. For me, the point is not when they're saying just crazy stuff. It's when they're saying crazy stuff and identifying specific people who they say must be stopped. And that's when I start being like, oh, shit. Right? When it's not just like, oh, my God, there's crazy shit going on. It's when it's, oh, my God, there's crazy shit going on. And Bob must, somebody's got to stop Bob. And I'm like, oh, Bob's in danger, right? That's the thing. Honk Banana No says, just drink your nasty clam juice already. We're doing that. I tried asking the bar if they could get Clamato in to make Caesars. I haven't heard back, so I don't think they'll have Caesars, but yeah. Ian BPK says, Japan Eats does some good food blogging there. That and sightseeing can be done without seeing a ton of anime otaku cultural places. Yeah. I kind of want to, there's a hotel that has been in operation since before America was a country. And I kind of want to stay there. I suspect you probably need to get a reservation 3 years in advance, but I kind of want to go. All sorts of stuff. Annabelle Feinstein, I don't think the super chat counter is working. Simply enjoy your drink. It's not working. YouTube is on the fritz. Fiona W says, not sure it's sound advice, but drink the Clamato already. It's good. Harbinger of imminent death. Does clam juice mixer ruin Malort or vice versa? I can't imagine that combo. Jordan the Lich, happy to catch you during free moments at work. We'll probably have to rewatch later since I keep getting calls. I'm sorry. Annabelle Feinstein says, now you have me contemplating running away to Chicago this weekend. I shouldn't, but it's so tempting. Driver flies the question. I have Tesla. Tesla's a nice drive. I don't own a Tesla, but yeah. Michigan Farm Boy, lawyers getting shit is evergreen material, so long as it's not a runkle. Or really any of my law tube follows. I mean, I hope we're not going to see anything like that. What is it? Made of fermented hot sauce. The guys love it. Fermented hot sauce is so much better. Joan Thor, how many clams does it take to make a clamato? I don't know, to be honest. E. Webster says, thank you for the 5 gifted memberships. Much appreciated. The World Wonders, if you do a Boston, Massachusetts meetup at some point and somehow don't make the minimum, I'd cover it to make sure it happens, as long as I'm still employed. Lol. I am nervous because the police there make me very, very nervous. E. Webster, thank you for becoming a YouTube member. Much appreciated. I would love to see you, but I'm in CA, which is either California or Canada, and can't do it right now. I'd love to do a California meetup. I need to do some Canada meetups as well. So, yeah, I've done one in Vancouver. Julia 543, meetup, print YouTube pic at home to use as name tag. Fair. And E. Webster, thank you for joining up. Welcome aboard. All right, we are all caught up. So if you ferment the garlic, is that still a botulism risk? If you're fermenting garlic, you should be doing it in an acid salt thing, and it should be okay. So, yeah. Have a wonderful trip. Hugs from Australia. I also want to do the Bay Area, like San Francisco. I definitely want to do that. So, yeah, we'll... there's all these places, and I know I'll do a meetup there eventually. It's just a matter of when, right? So, Annabelle Feinstein says, I'd love to see you as a presenter at the Killer Nashville Writers Conference. They host it annually. If they invite me, I would go, but I don't know when they would. Gwynny Bly says, have a wonderful trip. Hugs from Australia. I see somebody saying I missed one. What did I miss? I don't think I missed one. I hope. So, yeah. What is it? As my pop says, none of my business is none of my business, but please let Rob know we all care. Also, I'm so thankful you streamed tonight as I was able to complete 60 custom shot glasses. Now I'm curious as to what that's about. So, yeah. All right. Let's wrap things. Oh, this is an interesting one. I'd really love to host Runkle on a tour of the fantastical realm that is Tampa Bay. We could LARP across Xanth. I used to read so many Xanth books. And Tide, yes, I read the 4th from Rumble, so we're good there. All right, let's wrap it here. So I posted on Twitter. Everybody thinks when I get silly that I am drunk. And that is not what drunk Runkle looks like. Drunk Runkle gets tired and wants to go to bed. And so I'm not super pickled, but I'm feeling it. And the way I'm feeling it is that I'm like, I am tired. I want to go to bed. And so that's kind of the plan now. Yeah, we'll save the lawyers getting shot for next time. And I'm excited to see you guys. Did I do the closing story? I did. That was a while ago, so we did do that. So, all right. Good night, all. Thank you all for joining me, and see you next time. And looking forward to seeing some of you.